Morse, who is an associate member, followed by Jerry Thomas, who is a full voting member, Ken Foreman, who is our vice chairman. My name is TJ Hurry, I'm the chairman of the board. To my left is Ed Van Kuren, who is a full voting member, followed by Bob Dugan, who is the board's clerk, and Mary Berry, who is another associate member. Also with us tonight is Noreen Stockman, who is the zoning administrator, and Ashley DeMello, who is our recording secretary for the night. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considers requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. All decisions the board makes are made through the public hearing process. The board's goal is to hear testimony from the applicants and from the public, and also to allow a full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcements of the hearing and then present any pertinent information from the files, such as referrals from town departments and summarizing correspondences to and from the board. The applicant or the applicant's representative will then have 15 minutes to make a presentation, and then time may be extended by vote of the board. The board will ask questions to the applicant, and then the public will be invited to comment as well. Public comments should be directed only at the project, and we also ask you to please refrain from making any personal or derogatory statements. These public comments can include an opinion in favor or in opposition, or it just might simply be a question about the nature of the project. The chair will limit discussion in the interest of time in the event that comments become repetitive. All members of the public wishing to speak should wait to be recognized by the chair. Please come to the podium to your left. We also ask you to state your name and address for the record. And we typically limit public comment to 2 minutes per person. We will then either close or continue the hearing when the board is satisfied that enough information has been presented by testimony, and also when the file to make a decision by motion vote of the board, the hearing will be closed. In the alternative, we may continue the hearing to a future date and time. After the hearing is closed, no more testimony may be taken. And as for board discussion and decision, the board may then further discuss the project among ourselves and make a motion to deny or approve would be made and voted upon. Such a motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approvals of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, is a failure to carry and would result in denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. So on the agenda tonight, we have public comment, we have 3 continuations, 3 new hearings, and we also have items on our open meeting. So at first, we'll open for public comment. This public comment is for anything that's not on our agenda tonight. So is there anyone out there that wishes to make any sort of statement or comment prior to getting to our applications tonight? Okay, seeing none, we'll continue with the agenda.
So, Mr. Chairman, I'd like to make a motion to take the agenda items out of order this evening, starting with the continuations, 39-19, 797 Main Street.
Okay, is there a second?
Second.
Okay, second by Ed. So the motion was made by Bob and second by Ed. All those in favor?
Aye.
Good evening. Mr. Chairman, member of the board, just for the record, my name is Hal Chuba. I'm a consulting engineer with offices at 112 State Road in Dartmouth, and I represent the applicant on this application. As you recall at the last meeting, and again, we've been coming here, this is our 5th time maybe, and the issue is Cycle Avenue, the parking, whether Cycle Avenue is a private way or a public way, whether we have the right to park, whether you agree with the agreement, or there's other issues with access to of the Island Queen also. So we were waiting for the town council opinion on this. And as of now, I don't think we have an opinion from town council. We do have concerns, and also I have a memo from Ms. Stockman, I'm sure you have it in your file, stated also there's also concerns about the parking, the dumpster, the parking in front of the dumpster, the access. And so what we tried to do with the planning board, we tried to work with the neighbor, with the abutter, as we were directed to. We came up with an agreement. It seems like this agreement is nothing but trouble for things that we have no control of or we have no interest with. So at the last meeting, we also discussed options of maybe reducing the number of seats or reducing the number of parking required, or also asking the board for a reduction on the parking required. I had the impression at the last meeting that this board was inclined to approve a reduction in 10% if we were asked to do that. So we went back to the drawing boards. After discussion with my clients, we decided not to go along with the executed agreement. And I went back to the as I said, to the drawing boards. I have a revised layout here, and I'll go through it. And I do have also copies for the board members.
Thank you.
So we were able to make some changes on the site. We previously on what was submitted before, we had a common openings between the westerly property line and the abutters to the west. We are utilizing that side to park. So what we did, we also changed the orientation of the angle parking to 90 degrees. We were able to increase some few parking along the westerly side of the property. What we did, we also moved the dumpster from Cycle Avenue onto our property. We are providing a loading dock, or loading, not loading dock, a loading zone in front of the dumpster, not to be used for parking. That space was not included in the parking. Doing that, we can provide 22 parking spaces on site plus 6 for the apartments. What we need for the 44 seats, we need 22 parking spaces, and we need 6 for the apartment. That's a total of 28. Taking the 6 out, we're asking for a reduction of 10% on the restaurant parking. So that's taking 2 spaces out. We need to provide 20 and 6, total of 26 parking spaces that we can provide on our site. We are leaving the back of it open because we don't want to get into any lawsuits with any neighbors or anyone, or, we're just trying to develop our property in compliance with what the zoning boards would allow us to do. I think this plan would satisfy everybody's concerns. As far as parking, we do have the parking required. Now, in terms of enforcing the parking on Cycle Avenue, this is not our problem, this is not our issue. We don't want to get involved in this. This is up to the town, whatever you need to do. But as what we have here, we can fully comply with what we needed. And if the board is inclined to give us the 10% reduction that we, now, I did send this plan this morning to Ms. Stockman. She sent me back an email this afternoon saying this is different than what was the planning board. My intention was to go to the planning board also to modify the approved. We understand you can't vote on this tonight or you can't render a decision, but I did talk to the town planner, and he said he could place me on the agenda for December 10th. So I'm planning to go back to the planning board on December 10th to modify the parking layout. But I wanted to come here tonight also to get some feedback too, if, on this plan, if there's any changes, so we don't go back to planning, then we come back here and, so I would appreciate any feedback that you can give me at this time. Thank you.
Thank you. All right, we'll start with board questions. Mary, do you have any questions?
Not at this time.
Bob?
Just a couple of things. One's just a housekeeping thing, Mr. Chuba, on the plan with the 44 seats. When you do come back, just give us an interior plan that shows the 32 seats inside and then the 12 exterior.
Absolutely.
I know you said that the easement was voided, which is fine, but since we have the other signed easement, we just need something signed that shows that it's voided out. I like the plan much better, the one that you've come up with, and I think it does get you out of a lot of hassles. I do have some concern that the back of the lot is left open and there's no kind of a barrier at all. And the only reason I bring that up is because when I was in the area this week, and again, the building on the other side was doing their own deliveries, but they were using this site to do their deliveries from. And I just don't want to run into an issue in the future where they try to use that, but by the time you try to get caught up with it, it's too late. So I know you put curbing, precast curbing on the sides of the parking spaces, so maybe there can be some kind of a small abutment or barrier or something in the back, just so that people aren't traveling through your property just to get to the next one. And then I don't know, on the other side of the patio, you have that nice little group of bushes, there's like a long strip. Is that a sidewalk, or is that just asphalt, or?
No, that's asphalt, that's the showing.
I mean, you might want to just consider some kind of green space there, just because it's seen from the street, but, I mean, that's something you can go over later, but it would just have a better visual impact from the street. But that's all I have right now.
I don't have anything more.
Ken?
The only thing that, just assimilating your new plan, it's like the first parking spot on that way in.
Mhm.
Are you sure you have enough depth there that someone parking there isn't gonna get clipped by a car coming in there? I do see that there's, the landscaping does sort of make a jog to protect that, but it looks.
I can extend it a couple of feet if I need to, the landscape on it.
It looks a little short.
Anything else, Ken?
I agree with Robert, that this looks like it resolves a lot of these legal issues.
It gets rid of all the hassles next door, yeah.
Jerry, anything?
And this might be administrative, do they have to submit a revised application from what they originally came in with? Or will this handle it all? Revised plan plus site plan approval? Through the chair, so you'll understand too.
Yeah. So I think he can just send us text with the request to amend based on his changes. I don't think we need specifically a new
Okay.
application.
In site plan approval, obviously. Thank you, no further questions.
Okay, James?
No questions.
So I see on these new plans that you did list residential parking toward the rear of the building. Will that be exclusively for
Yes,
the apartment? Will there be signs to that effect?
sure.
And those are all the questions I had. Anything else from the board? Any questions, comments, concerns regarding this project from any members of the public tonight? Seeing none, back to the board.
Well, since we can't vote on this tonight, and we'll need to find out what happens at planning board, I'd make a motion to continue.
Okay.
Second.
Mr. Schuba, we do have an
Sure.
agreement for you to sign, just extending the hearing process with us.
And you
And
want to
Noreen,
pick
what's the
that
date?
We'll stick them
Thank you.
What's the date for the
on January 23rd. January
23rd?
23rd.
All right, so our next opening is January 23rd, so I'd make a motion to continue to January 23rd.
Is there a second?
Second.
And you're available on that date, I assume?
Yes.
All right, so motion to continue this hearing to January 23rd of 2020. All those in favor?
All right,
Aye.
Aye.
Thank you.
Thank you.
Mr. Chairman, again, taking items out of order, I would make a motion to go to the new hearings, starting with Clancy, application number 70-19.
Motion was made by Bob. Is there a second?
Second.
Second by Ed. All those in favor?
Aye.
Aye. So we have application 70-19, Clancy, 457 Courier Road in East Falmouth.
I don't know if those are the right, did I hand out Deacons? Do those plans say Courier or
There,
Deacons?
we're checking. Yeah, that's Deacons.
Is this the wrong one?
Yeah.
Yeah, no, I did that one.
Pass them back.
So application number... The two plans are just mixed up. So application number 70-19, being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Joseph M. and Marjorie K. Clancy of East Falmouth, Mass. has applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C, 240-68A8, and 240-38G1 of the Code of Falmouth to remove the existing in-ground pool and shed and construct a garage in the front yard more than 50 feet from the front property line on subject property known as 457 Courier Road. For referrals, Health Department, existing septic system and close to the proposed garage is shown in the health's records. However, a perk test was done recently in preparation for a new septic design. Applicant would need to show that there is a 10-foot of separation between the existing septic leaching and the proposed garage, or obtain a disposal works permit for the new septic system before health can sign on the building permit. The plans do not show any habitable space over the garage, and it appears they're not requesting for an increase in flow. And I think Mr. Bunker already has settled that with the Health Department. Concom, proposed work is outside of Concom jurisdiction. Engineering, just the general condition that will require addition of dry wells, rain garden, or other stormwater measures for the new roof area at a minimum. Planning Board, no comment. Assessors, no comment. Fire Department, no comment.
For the applicant tonight?
I am. I am the owner of the property along with my wife, Marjorie Clancy. I'm Joseph Clancy, 457 Courier Road. Tom Bunker is expected to join me, so when he gets here, we'll go together. But basically, BSS Design has prepared a current site plan showing the existing conditions. The home was built about 1980. At that time, I received a special permit, 72-80, to construct the dwelling. Subsequently, there were issues with the pond, and we thought it would be enjoyable to have a swimming pool, but being on the pond, we obtained a building permit at the time, and went through the process and got a swimming pool and a resulting shed in the front yard. It conformed to the zoning at the time, and we got a building permit and occupancy permit, and we've enjoyed it for a long time. As we've aged, we've decided that a garage would be probably better suited to us and to the site. And so what we have before you is an application to put the garage and a new shed that would be conforming in the front yard. The design of the house doesn't lend itself to attaching the garage in any way, shape, or manner. The placement of the garage is on the bedroom end of the house, and I think that would accommodate us nicely with the layout of the garage, with the setback requirements and the setback from the roadway. The shed was built at the same time as the pool, and an extension was put on that is a bit non-conforming, so we're gonna remove the shed and build a 26 by 26 garage with your approval, and adjoining the garage will be a 12 by 20 attached shed. As you can see by the architectural plans, the shed is definitely a lower pitched roof, and it is meant just for wheelbarrows, snow blowers, lawn mowers, all the related equipment. We're pretty active in gardening. We enjoy working in our yard, so we have a lot of tools and implements that would go into the new attached shed. So the shed is an important item for us to be able to get attached to the garage for all of our items. In prior years, in all of the certified plot plans I had, I found that the house was in conformity with the 10-foot setback. Well, in discovering with the new equipment that the surveyors are using, the right side of the garage was found to be 9 feet, actually, from the lot line. So that's one of the items that is non-conforming with the property that I can't do anything about, but is shown on the plan and for your information. We had the perk test done. Scott from the Board of Health came out and witnessed a perk test, and we found to have sufficiently good soil, similar to what I found when I had the original perk test done when I built the house. We will probably, at the time of construction, with your approval, reconfigure a new leach field so that it is in the same general area as the former pool, and will conform to the 10-foot separation between leach field and any structure. We are presenting no habitable space on the garage. We're not trying to change any further bedrooms. We even considered a drop-down stairway, but we feel that with the shed, we have enough storage on one level so that we don't have to be going up over the garage for additional storage. So there's no more habitable space. It'll just be for 2 cars, and as I said, for attached shed purposes. So I think that just about summarizes it. I brought along pictures of the existing shed. If the board would like to see that, I'd be happy to show them.
And if you'd like to, you can give that to Bob, he can stamp them in.
Good, thanks.
And we'll turn it to board questions if you're all set with your presentation.
I am. That completes that. Thank you.
Great. James, do you have any questions?
No questions?
Ken?
So if I understand, then there's not a loft or anything over the garage, it's just cathedral ceiling, or?
It's going to be a flat ceiling. There will be no loft. It'll be flat, just for
But no
the
access?
door operators. That's correct.
Okay, and is this heated, the garage?
It's possible. My son, who's the builder, is encouraging me to heat it. I'm not sure if it's going to be in the budget.
Right, okay, and plumbing?
No plumbing.
No plumbing. I think those are my questions.
All right. Ed?
No, nothing, pretty straightforward.
Bob?
Just a quick thing on that, so on that nonconformity, was that the current garage that's the 9-foot?
No, that's the right corner of the house.
Oh, it's the house that's 9 foot, okay.
The existing shed is to the lot line. That's going to
Oh,
be
I see it
removed.
now, yeah. No, I have no
The new
questions.
garage and shed will be 11 feet from the lot line, so it'll be brought into compliance, as well as the garage will be over 50 feet from the road.
No questions.
Mary?
No questions.
Bob, do the engineering referral recommend dry wells? I'm not sure if they show on the plans.
Yeah, did for any minimum for any of the roof area. There was a,
Engineering did request dry wells, and we're planning to do that.
You're amenable to that?
Absolutely.
And we usually, you'll see in our conditions, we usually just had, we leave it to your engineer's discretion as to where to place them and what capacity they handle.
and I know Tom Bunker isn't here right now, but he did have a response regarding that health department comment. And this was from November 19th. And he said, in response to the health department referral, he was sending a plan which shows a septic upgrade proposed at 457 Courier Road. It was our intention to submit the plan last week, but it just wasn't done. He does say that we will submit a plan to the Health Department for their review with a copy to us for informational purposes. The septic upgrade plan was prepared as a separate plan distinct from the garage proposal filed with the ZBA, and is not a revision of the ZBA plan, and he did say he would bring some PDF files tonight. But it looks like they've handled whatever.
Okay. Any other questions from the board at this time? Any questions, comments, concerns from any members of the public regarding this application? Seeing none, back to the board. Who would like to proceed?
I'll move to close.
Second.
Okay, motion to close by Ken and second by Ed. All those in favor?
Aye.
Aye.
I'm happy to move to approve.
All right.
Second.
Motion approved by Ken, and that was a second by Ed. Findings?
So, he has gotten rid of the non-conforming shed, and the current proposed project conforms. So that's improved. There's no habitable space above the garage, no plumbing. I don't know if it's appropriate to mention the septic upgrade, because it's not really part of this.
No, we can always do that in the conditions they meet health.
So, I guess in that sense, it conforms with 24216, improves the usability of the lot.
And then just add in 240-3C, 240-38G1, and 240-68A8. And even though there's no habitable space, they may at a future date heat the garage.
Right, that's a reasonable find. And then, I guess it would be as per the plans, and then there was an engineering comment on the,
Yeah, and the applicant did say that they will redo the leach field to meet the health department comments at construction.
right, well, didn't that pertain to the septic upgrade, or?
The set with the upgraded leach field.
Right,
It's also amenable to adding dry wells and,
that's what I was
oh,
driving at.
okay, yeah.
So then I guess we would say as per plans, and then with dry wells to be added as
Yep, per engineering comments
recommendation
and
of
per,
engineering.
and per health department comments for the plans that are required there.
All right, anything else? Okay, so that motion to approve was made by Ken and second by Ed. All those in favor?
Aye.
Thank you very much.
Congratulations.
Your presentation.
Do they already have a Deacon's Ave down there?
Yeah, they
These
have-
are for like the next one. I think.
So again, taking new hearings out of order, make a motion to go to 71-19 Pernock trustee, 40 Deacon's Ave, Falmouth.
Motion to take application 7119 out of order. Is there a second?
Second.
Second by Ed. All those in favor?
Aye.
So being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Christopher E. Pernock Jr., trustee of Easton, Mass., has applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C1B of the Code of Falmouth to reconfigure the first floor deck and construct a second floor deck addition on subject property known as 40 Deacons Ave, Falmouth, Mass. For referrals, Concom approved an RDA for the work on November 6th of 19. Engineering. Property must not direct any stormwater runoff to public property abutters of rights of way. They have all made a note that there is an address of number 40 engraved on a rock at the corner of Vernon and Deacon, but they recommend the following condition for any approval, that upon completion of construction, the applicant shall post the address for this residence per section 99-1, affixing of legible numbers required in a time limit for compliance, so they'd have to label the house. Assessors Department, this includes lots 12, 13, 22, and 23. Planning, no comment. Fire Department, no comment. Health Department, no comment.
Okay, and for the applicant tonight?
Hello, my name is Garrett Frost. I'm with GF Architecture, North Falmouth, representing Chris and Kathy Pernock, 40 Deacons Ave. Client requested a renovation of the exterior deck that is shown on the site plan, cursor right there. Currently, it is a curved corner, and the client requested that this get renovated so that it's square. And then, in addition to that, adding a roof and a second floor deck within the roof property, directly above the existing deck. So, the existing house is pre-existing non-conforming by dimension from the front yard, as well as the new site survey revealed that it was non-compliant by structure, paving, and parking. By changing the deck, first floor deck, we reduced the length of it so that the area remained exactly the same. And then the second floor deck is within a roof with eaves that match the existing structure. And the deck is placed within that roof. So, this is the property. It's a bungalow facing on Deacons Ave, facing out to the harbor. This is the round corner, which they would like to make it square. The client loves spending time on this deck, and it's very difficult with the round corner to put any furniture in that area right there. And then this bay right here would be removed, and then the existing roofs here would be extended. A column comes up from the corner and creates a structure where a roof deck is put in. That the proposed roof deck, first floor squared off deck is here, and then this area right here. Inside elevation is the new roof deck. The roofs are extended out from the existing, wrapped around, tied into both sides. New doorways and things like that. That's the existing roof that's going to remain unchanged. We put a column up from the first floor, put some brackets that are similar to the existing bungalow project, and they are really excited about potentially using this right here. So it's a really simple, straightforward renovation addition, and I believe you have a letter from the neighbor that is directly to the side, is directly to this side of the house, giving thumbs up to the project. I think that's about all the explanation I can give you on the project. Any questions?
All right, board questions. Mary, any questions?
No questions.
Bob?
No questions.
None.
Ken?
So the overall height of the structure is not increasing?
Anything else? All right,
No
Jerry.
question.
James? And no questions from me, so, any members of the public, questions, comments, concerns regarding this project tonight? Anyone at all? All right, seeing none, back to the board.
Motion to close?
Second it?
Motion closed by Bob and second by Ed. All those in favor?
Aye.
And how would the board like to proceed?
Motion to approve?
Second.
Motion by Bob and second by Ed. Findings?
The current nonconformity is at a front yard setback and also to lot coverage by structure and structure parking and paving. Structure is 25.9%, structure parking and paving 47.5%. Neither of those will be changing. Applicant will be squaring off the curvature of the first floor deck, but the actual deck area will be remaining the same. They'll be doing extension, they'll be adding a second floor deck with additional roof line. Meets 240-3C1B, 240-216. Not substantially more detrimental, and the squaring off of the lower level deck increases utilization of that space.
Okay,
There's also, and there is a letter in the file from the neighbor that they are in support.
all right. Any conditions?
Per plans. Stormwater measures per engineering for any of the additions in the roof line.
Put the house number on the house.
Yep, and also the, let me get the section just so you have it. It's 99, I think it's 99 dash. We should probably also put a finding in that they do have an RDA from Concom. The condition will be, upon completion of construction, the applicant shall post the address for this residence per section 99-1, which is a fixing of legible numbers required, and a time limit for compliance. Should also put in the findings that there's, at this time, there's no alterations are being proposed to the rights-of-way or any changes to the rights-of-way.
All right. Anything else?
That's it.
Okay, so that motion to approve was made by Bob and second by Ed. All those in favor?
Aye.
Aye.
Thank you. You're welcome.
In history.
So, again, continuing out of order, make a motion to take new hearing 69-19, 331 Edgewater Drive, LLC, 331 Edgewater Drive, East Falmouth.
Okay, so that was a motion to take application 6919 out of order. Is there a second?
Second.
Second by Ed. All those in favor?
Aye.
So being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that 331 Edgewater LLC of Rentham, Mass. has applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C and 240-68A8 of the Code of Falmouth to raise the non-conforming detached garage and construct a two-car garage with habitable space above on subject property known as 331 Edgewater Drive West, East Falmouth. For referrals, and I think this might be modified, but from Scott McGann, the health agent, that the rec room over the proposed garage meets Title V in Falmouth's local septic regulations definition of a bedroom. This would be considered an additional bedroom requiring an upgrade to the septic system. The current septic system is sized for 2 bedrooms with a current assessment of 2 bedrooms. Engineering. Not directing any stormwater runoff to public rights-of-way. While Edgewater Drive is a private way and outside a jurisdiction for a driveway permit, it isn't clear if the driveway will be asphalt, but we are assuming it is. We recommend that the applicant consider setting the garage elevation and driveway grades. It isn't clear from the plans what the garage floor elevation or driveway grades will be, so that stormwater runoff is diverted from discharging to the street and instead directed into an on-site area for infiltration. If the driveway will be pervious, this is not a concern. Section 240-112, Stormwater Management B, Design Requirements requires that uncontaminated runoff be directed to recharge within the lot of which it originates. We defer to the board to determine if this project as designated meets this zoning requirement. Concom, the project was approved on 11/6/19 with an order of conditions pending, and there's an attached approval plan and a staff report. Water Department, per Water Department regulations available online at the department's webpage, all occupied structures need a dedicated water service. The proponent shall apply for a new service in meter for the detached structure with habitable space. Planning Board, no comment. Fire Department, no comment. Assessors, the assessors request a final inspection prior to any sign-off. And that's all we have right now.
And for the applicant?
Good evening, Mr. Chairman, members of the board. For the record, my name is Kevin Clower. I'm an attorney with Ament Clower Law Firm here in Falmouth, and I represent the applicant, Michael O'Brien, the manager of 331 Edgewater LLC, also the owner and the applicant in this matter. I do have a very minor revision to the plan, just the floor plan. That was submitted electronically earlier today. I'll go over what that changes in a little bit, but it shouldn't affect the ability to proceed or not this evening, I don't believe. The applicant is seeking permission to raise and rebuild the existing non-conforming garage on their property. This property is located on the westerly side of the Seacoast Shores Peninsula on a lot of 13,200 square feet and is located in the residential C zoning district. A portion of the lot's within the velocity zone and a portion's within the AE flood zone. The applicant purchased this property 2 years ago for his young family. He wants to make the space more useful and attractive. He wanted to be here this evening, but he unfortunately had prior obligations as he has to bring 2 of his daughters to Frozen 2 tomorrow morning and couldn't make the trip. The existing garage is a 1-story, 1-car garage with a ridge height of approximately 14 feet. It's non-conforming to front yard setbacks being 13 feet 7 inches where 25 is required, and side yard setbacks being 9.5 feet where 10 feet is required. It's additionally non-conforming in that it's an accessory structure located in the front yard, less than 50 feet from the street. The applicant's proposing to raise the existing garage and rebuild a larger, more conforming structure, which will require a special permit due to the existing nonconformities. And that permit will be under section 243C and 24068E. Section 243C states that a pre-existing non-conforming structure may be altered or changed by a special permit, provided that it's not substantially more detrimental than what presently exists. The board is asked to consider the standards of 240-216 and whether or not the proposal creates a new dimensional nonconformity, impairs views and vistas, or doesn't reasonably conform to the average dimensions in the neighborhood. This proposed garage is in a similar location and footprint to the existing. It eliminates one of the existing nonconformities and improves the other. The side yard setback is changed to 10 feet, as is required. The front yard setback is improved from 13 feet 7 inches to 14 feet. The number of bedrooms will in fact remain the same, which we'll discuss. And the lot coverage, though it does increase, still remains at only 16.2% by structures, which is well under the 20% that's allowed by right. The proposed ridge height of the garage is 22 feet. We did receive the referral from the health department, and as originally proposed, they determined that the space above the garage would be would constitute a bedroom under the Title V regulations. So I spoke with my client and with Scott McGann, the health agent, and the owner agreed to change the plans, which were revised and submitted to you now. The space above the garage is not going to be heated. Mr. McGann was comfortable with that change and signed a designation agreeing that that would not constitute a bedroom. Correspondence signed by him stating that was submitted to the zoning board this afternoon. As was mentioned, this was reviewed by the Conservation Commission, was well received, and the order of conditions is expected shortly. So what we have here is an elimination of the non-conforming side yard setback, the improvement to the front yard setback. There's no new non-conformities created. There's no impact of using vistas, and it does reasonably conform to other properties in the neighborhood. To me, this is a good project. It's encouraging to see a new generation of families making Falmouth their home, whether it's full-time or part-time. And this proposal will allow them to gain more enjoyment from the property. It increases the utility, and it's an aesthetic improvement. There's no detriments to this project, and certainly none that could be considered substantially more detrimental than what presently exists. For these reasons, and given these considerations, I believe that this board can and should grant the special permit, and I'd be happy to address any questions that you might have.
Thank you, Attorney Clower. Mary, do you have any questions?
Not at this time.
Bob?
Yeah, so Kevin, I know that you've changed it to unheated space on the second floor, so what is that second floor gonna be used for? Since it's-
So it can be storage space, it can be finished storage space, because the Title V code specifically allows for storage space. It can be used as additional rec space. It's a small house, he has kids, he wants a place to kick them out when it's a rainy day.
Right,
but-
so where it has that cantilever deck addition with sliders out to the deck on the second floor, I assume it's gonna be more usable space than
Oh,
storage?
it's certainly gonna be usable, and but it's gonna give a beautiful view over the water. So, I mean, I think they wanna take advantage of the space as much as they can.
Would the applicants be amenable to a deed restriction for 2 bedrooms?
I think there is one in place. It's a two-bedroom, it's a two-bedroom home. They don't want to do a deed restriction because they do at some point want to make an addition to the house to add a third bedroom.
So if we deed restricted as part of the special permit, that could be removed once they did a 3rd bedroom and got an upgraded septic?
Well, I think that we would rather not do a deed restriction at this time, especially considering the Board of Health was comfortable with this not being a bedroom. It's something that we discussed. The problem with a deed restriction is once it's on, it's hard to get off. And so to say that we could change it later isn't necessarily true. What we've done in some circumstances is say that it's a 2-bedroom home until such time as a septic system would be installed that would allow for more than that. But the issue is that they want to make sure that, though this will be unheated, that there's no way this would constitute the 3rd bedroom. So I think that they prefer not to have the deed restriction at this time, and I don't think it's necessary given that the Board of Health, or the health agent rather, was comfortable with this as not a bedroom.
Because I guess my only concern would be that the garage space downstairs is heated. It has a bath, it has closets, it's
It
open.
has a utility room and not closets.
The plan shows 2 sets of closets.
That's storage space. It
And it has an open stairway to the second floor with a deck. So I guess my concern would be if somebody did start using that as a bedroom, without a deed restriction or anything on that, there would be no likelihood to bring that up for a septic improvement.
So-
It looks like, and they may not have intended it, but it very much appears as a setup for a separate living space.
It's certainly not intended as a separate living space. And I don't necessarily think that we can assume that someone intends to make it a separate living space. It's intended as additional space. It's a small house that really doesn't have much room for expansion in its current location, given the conservation issues there. So what they're trying to do is create some usable space that will be storage and does not constitute a bedroom, as it won't be heated. So I think that I think the issue's been resolved as far as the bedroom count goes. And I think that we can't assume someone will do something they're not supposed to do. I think we approve things in a way that we assume people will follow what they're supposed to do. The gentleman's a builder. He knows what the codes are. He takes his obligations under those codes very seriously. And I don't think that we can say, well, they might do that, so we need to.
So they removed the heat from the second floor, just so the health department couldn't define it as a bedroom, is that correct?
No, we, in conjunction with the health department, we talked about ways that this would not be counted as a bedroom, because the intent is not to use it as a bedroom. part of the definition of bedroom actually says a room intended primarily for sleeping. And so there is a question of intent, and the intent is not to use this as a bedroom. So in talking with Mr. McGann at length yesterday and today, this was the solution that was arrived at.
That's all I have right now.
I have nothing.
Ken?
I'm good.
Jerry?
So you think your client would be amenable to the obvious that this is only a two-bedroom, the upstairs will not be converted to a bedroom?
Correct.
There's no plumbing fixtures going up there?
Correct.
There are electrical fixtures going up there?
Correct.
Yeah, I hadn't had a chance to look. at
Yeah, I mean,
it.
it'll be finished space, but it's not gonna have any plumbing.
Okay, it would be habitable, but not necessarily
Well, it's not
a bedroom.
heated, so it's not heated, so
Okay.
it wouldn't be considered habitable for that, under
Okay.
that.
In the closets downstairs,
Mhm.
I don't know if there's a difference between a closet and storage space.
Well, I mean, I think closet is storage space.
Okay,
No, you
difference
put
without
heat.
distinction.
Anything else, Jerry?
No, thank you.
James?
My question's been answered.
So maybe to address Bob's issues, is there a door shown on this, well, for lack of a better term, maybe a foyer leading up to the?
There is a door in it from the garage to the upstairs.
Would you be amenable to cased opening, maybe to eliminate? part of
I actually think there's a building code issue with that.
it?
There
Okay,
is, there is.
all right. So much for that idea.
I had the same thought, and I
Yeah.
was told that we couldn't do that.
Okay, any other questions from the board at this time? Any members of the public have any questions, comments, concerns regarding this project? Seeing none, back to the board.
So I don't know if you want any, just in discussion, I understand what the plan is. I feel very uncomfortable when they change something just not to meet a definition, especially where this house is on the water, and it would need an increased septic system. So just know how they know where I'm going in advance. I would not be in favor of this without a two-bedroom deed restriction. I can understand that that restriction could be removed if they decided to finish off the space, but right now you've got a heated garage with a bath, closets, in an upstairs area with a cantilever deck and sliders, and it just does not seem to me that that would not be used, especially in the summer or rec space, as an overnight area. So if the deed restriction was there, I would be in favor. Without the deed restriction, I would be voting no.
I have a question. The square footage of the garage
Mhm.
versus the square footage of the house, the existing house, could you
I don't
feel for that?
I don't know the answer to that
Is-
question.
Is the garage bigger than the house?
I don't believe it's bigger. They're probably fairly similarly sized. But it's not, we're not looking for an accessory apartment, so we don't run into that 40% threshold.
Why would you need it heated?
I think there's lots of reasons you could potentially want a heated garage, specifically if you're doing any work on a car.
The bathroom would freeze, so that's probably the easiest answer.
That's a really good reason.
I guess my other question would be, why would you need a powder room in a garage?
I've seen a lot of garages with a quarter bath or a half bath. I think that's not unusual, especially when it's a detached garage, that, if someone doesn't want to be running back and forth.
So what is the primary purpose of the garage?
The garage is to be used as a two-car garage with storage, because there's no other garage on site, there's no shed on site. So, the garage is used for the cars and storage, and then there's space above that'll be used for storage and rec space.
But there is an existing garage.
An existing one-car garage that's pretty small, and they'd like a more useful garage space.
Any other questions?
I guess if we're polling people for opinions, I'm not sure adding a deed restriction, I think it just adds governance that's not needed to this. We have a robust health department, I think we have to trust the system. If they put it in surreptitiously, they're not going to be able to sell it. So I just think for the ease of the permitting process and governance, we just simply restrict it to no living in the second floor. And I know others may disagree, but he's gonna have to come back to us for a special permit anyways. And if you don't trust people to come back to us, let's not approve this permit, because we obviously can't trust them.
How does anyone else feel?
I don't have a problem if the decision includes a two-bedroom restriction. I don't think we need to insist on a deed restriction.
Oh, okay, I agree with you. That was
For
no.
you, you're learning.
So that's a two-bedroom restriction, but no deed restriction?
Correct.
Yeah, okay,
Yeah, I'd go along with that.
yeah.
And from where I sit, I'm comfortable with the decision saying it's a two-bedroom home, because the decision could be amended by a further decision.
Right.
Amending a deed restriction is more difficult.
All right. I tend to agree with the majority of the board. Sorry, Bob.
No, that's okay.
That's all right.
If you do the two-bedroom restriction, I would just like a copy of it to the health department.
That would make sense.
That way they can keep it in their file,
Right.
because they don't check the registry of deeds. And then if an expansion comes up, at least it'll red flag them.
And if we do that, would that sway you on our side?
Yeah, as long as there's a restriction, I just want to make sure the health department's aware, because, you know, we see these cases that,
Any addition to the property would require a special permit, so it would be back to modify, either modify this permit or obtain a new special permit.
We probably also need a notice to the building commissioner, so it's in his file.
All right, so I think we're all in agreement. Does anyone want to make a motion to close?
Move to close.
Second.
Okay, move to close by Ken, and I'll give that to Jerry as a second. All those in favor?
Aye.
hi,
Aye. And how will we proceed? Not everyone at once.
Move to approve.
All right. Move to approve by Ken. Is there a second?
Second.
By Ed. Moving on to findings.
So, let's see, so we're gonna find that the second floor is unheated space, and that there is a letter from, it's the engineering, or is it health,
Health.
That was from
health acknowledging that that does not count as a second bedroom, that the applicant is amenable to a two-bedroom restriction on the, currently.
maybe a finding that if there's an increased bedrooms on the property, a septic upgrade would be required.
Yeah, I think that's a good finding. And then in terms of
Well, you can put they're eliminating the side yard,
nonconformity,
and they're improving the front yard. Meets 240-3C and 240-68A8 and 240-216. The applicant said the second floor will only be used for storage or recreational space. Not habitable space, would have electric but no heat. I don't know how it affects the, so on the water department, does that still need a separate line? Because they made all their comments based on the habitability, so I assume it would be the same?
Apply to the water department.
I
Cover
would
us up.
assume, because the existing,
We'll have to work through the water department anyways and
Right.
pulling
because
permits.
the existing garage does not have a bathroom.
That's true.
so,
Yeah.
Yeah, obviously.
I think also make a finding that there's an order of conditions with Concom.
Anything else for findings?
in terms of decision, restricted to two bedrooms.
Restricted to two
should be
bedrooms.
Explicitly stated.
Per revised plans, showing no heat on the second floor.
If I can just note on the two-bedroom restriction, until and if such time as a septic system is installed that would accommodate more. I just want to make sure that's
Well, you need to
clear.
come back anyway.
Of course, but I would be coming back for it, but I just want to make it clear that it's not limited in perpetuity into two-bedroom system.
Could either do that or put it in the findings. I don't know.
What's in both?
Okay.
Anything else for conditions?
No, maybe just, but maybe just in findings that the original plan, the health department's comments was, it would have met the definition of a bedroom, which would mean they needed an upgrade. But the revised plans with no heat means it isn't defined as a bedroom, so they currently can stay at a two-bedroom.
All right, I think that's fair. Anything else?
And just the, copy of the two-bedroom restriction would go also to the health department.
So we can just, once we record the decision, I'll provide a copy to the health
Yeah,
department
we'll
as
just
well.
put as a condition that it's provided to the health department for their files.
All right. So a motion to approve was made by Ken and second by Ed. All those in favor?
Aye.
Aye.
Thank you very much. Appreciate your time. And happy Thanksgiving.
All right, so now, again, a motion to take out of order back to continuations. Application number 63-19, Cachadorian Ballas, 18 Tashmere Drive, East Falmouth.
Okay, motion to take that out of order. Is there a second?
Second.
Second by Ed. All those in favor?
Aye.
Aye. So we have application 63-19, Cachadorian Ballas, 18 Tashmere Drive in East Falmouth. And I believe there's correspondence from the building commissioner on this?
Yeah, let me just check this. So I guess this was received this evening from Rod Palmer, Building Commissioner. It's dated November 20th, 2019. Addressed out to Troy Wall Associates, Attorneys and Counsels at Law, 90 Route 6A, Sandwich, Mass. Regarding the request for zoning enforcement, 18 Tashmere Drive, Falmouth. Dear Mr. Wall, I will not be initiating action relative to your request for enforcement. Your request for enforcement dated October 17th, 2019, copy attached, did not include a site plan, photos, nor does it articulate the nature or use of the floats. For this reason, no action will commence. Thank you, Rod Palmer, Falmouth Building Commissioner, Zoning Enforcement Officer, and the copy went to us as the Board of Appeals.
All right, Attorney Wall, I know we just received that correspondence just before the meeting started, so I'm not sure if you were aware of that.
I also received it just before the meeting started.
Okay. And
So-
whenever you're ready.
Thank you. So through the chair, for the record, my name is Brian Wall. I'm an attorney. I have an office in Sandwich, and I represent the petitioners before you, Stephen Bayless, owner of 64 Muskeget Road, and also Michael Cachadorian, owner of 77 Muskeget Road. And both of the gentlemen are here with me tonight. This is a continuation of a hearing. I will address the correspondence that just came in, but I kind of want to do it in an order that makes sense. And so I'd like to just remind the board that my clients own, it's on the plan, this property here and this property here, and they are trying to permit and license the dock that's shown here so that they could park a boat here and here. But as they went through the permitting process, and I'm not going to repeat everything I said the last time, the neighbors, Mr. Penticus here, appeared and said that the proposed dock would interfere with the use of his floats, but it came to our attention that Mr. Penticus does not have a special permit for his floats, and we sought enforcement, and the board granted that request the last time. And also, the Dundulis property here, and I know that Mr. Hoyt is here and Mr. and Mrs. Dundulis are here, they also appeared at the hearings in opposition and said that the dock would interfere with their existing floats. And at the time that they were saying that, their floats were these big red ones, which were 8 feet by 20 in size and did not have, we contend, a special permit. They do have a Chapter 91 license for the floats that are shown in brown. And as you'll hear me say tonight, during the course of all of this permitting and litigation that's developed as a result of it, they have taken out these bigger floats and they've put back in these floats. And that kind of focuses me on where the hearing went last time. After I gave my presentation, the Dundulis' attorney, Mr. Hoyt, presented the board with a letter, and the argument seemed to become very focused on a 1995 special permit. And we both agree that there is such a permit. In fact, I submitted it to the board in my materials, and Mr. Hoyt submitted it in his materials. But we had a disagreement, excuse me, a disagreement over what that permitted authorized and what it didn't. And essentially, we contend that that permit authorized this bulkhead right here, which is in the intertidal zone and requires a Chapter 91 permit. And you'll remember back in the 90s, there was an amnesty program. The DEP was trying to get licensed structures that needed licenses but didn't have them. And as I make clear in my arguments tonight, we believe that the special permit was just for this, but at the end of the permitting process, there was a plan submitted that does show floats here and here. And Mr. Hoyt made the argument that the permit refers to the plan shows floats, and therefore the permit approves the floats. And we disagree with that. And I have, I gave reasons last time, and I have additional reasons this time. So, to dive into it, I did some research, and I could not find a case on point either way. And I suspect that Mr. Hoyt did not find one either because he doesn't have a case that says or supports his proposition. I think it's a logical argument. But I think if we go to the basics of zoning, I think, provide help and an answer to this question. So one of the basics of zoning is that the board's decision is confined to the matter that's before it, and that the board cannot make determinations about matters that are not before it. And there are practice manuals for people like me and engineers and I guess appraisers now are doing zoning. But there are manuals out there that say, be careful that when you file an application, make sure that you request all relief that is necessary for what you want to do, and make sure that request is clear and unambiguous so that there aren't problems later with disagreements over what was granted and what was not. And also, another basic is that if the board does not issue its decision in a timely manner, and there's a constructive grant of permission, the constructive grant goes back to the application. And so the application becomes the operative document and becomes the relief that is granted under those circumstances. A related concept has to do with the process, which is the public notice, which are read at the beginning of every hearing and appear in the newspapers. And the law of the public notice is that notice must be sufficient to inform the neighbors of what the board is going to discuss and what the board is going to decide. And similarly, the board's ability to make a decision is limited to that notice, because you can't give notice for one thing and then do something else because it doesn't provide the neighbor's notice. And so with those concepts in mind, I'd like to just go through the special permit application. And this was part of my initial submission, but I think it's important, and I'm using these graphics this time to go through it and make it easy. So this was the application that was filed in 1995. It was an application, the section number is different, but it's essentially the section that we still use today, 240-77, to dredge or fill or otherwise alter a wetland. The application was filed July 7th, 1995 by John R. and Susan E. Augusta, 18 Tashmu Drive. The description of the property and the project site is existing man-made canal, and let me just go back. The description of the property and the project is the existing man-made canal. And other here describing the project, riprap or bulkheading, none proposed because it was already existing. Other, docks, piers, and et cetera. And I would submit to the board that that would be an appropriate place to ask for floats. And the applicant said not applicable. The project summary for the legal notice was proposed to license under MGL Chapter 91 Waterways Amnesty Program 80 linear feet of bulkhead. There's no reference at all whatsoever to any floats. So that's what was applied for in July of 1995. And the permit refers to an Army Corps of Engineers authorization, and this was attached. And this, essentially, the application was to permit and what the Army Corps had already given permission. And the Army Corps gave permission to construct and maintain 1,835 linear feet of reinforced concrete slab bulkhead. Again, there's no mention of any floats. This was the license from the Army Corps for the bulkhead. So, based on that application, a public notice was issued, and the public notice was just as asked for in the application, which is on the application of John R. Augusta to license and maintain an existing bulkhead. Again, no reference whatsoever to floats. Interestingly, the application was filed, and I'm gonna make a comment later about the timeline, and so if I could ask the board to note these times. The application was filed in July, but for some reason, publication was not made until December. But it was made in December, and then that triggered the normal permitting process, which includes all the comments that you read each hearing from various town officials. And so the harbor master on December 11th submitted a letter that was received on December 12th for a whole slew of wetlands hearings. And again, I think for those that remember, back at this time, there was a whole flurry of activity to license these structures under the amnesty program. Otherwise, fines would be applicable or higher application fees. And we have here that he made an on-site inspection of the following applications, and here we have Mr. Augusta to license and maintain an existing bulkhead. No problems for mooring or navigation, no reference of floats. I noted on the same list, there were other applications that did mention floats, and so I think that one that was seeking to get permission for floats would be behooved to ask for it, and they did, but Mr. Augusta did not. The Town and Natural Resources Department submitted comments the next day, December 12th, received December 13th. Again, applications to license existing structures. Again, Chapter 91 was all over this. Mr. Augusta for a bulkhead. Other people sought other relief, including for a float for Mr. Clark, but Mr. Augusta just sought a bulkhead. The Shellfish Constable or Warden, December 15th submits his materials, and again, a whole slew of wetlands hearings were going on December 18th. And we get to Mr. Augusta, Project OK, existing bulkhead. And excuse me for this, upside down, let me rotate the view. So, we get to the Selectmen's hearing on December 18th, the evening of December 18th, and this is the plan that is submitted. And as Mr. Hoyt has pointed out, there are in fact some floats shown on there. But I would note the title of the plan was John and Susan Augusta to maintain an existing concrete and steel bulkhead in and over the waters of a man-made canal. The selectmen held a hearing on this. Oops. Uh-oh. Sorry. So the selectmen held a hearing on December 18th, and again, a whole bunch of wetlands were going on, and when Mr. Augustus came up, the notice was read to license and maintain an existing bulkhead, and Mr. Costa at the hearing presented the plan for the first time. So this plan was put before the board during the hearing. Nevertheless, he informed the board that the bulkhead and revetment have been in existence for 25 years. No work is proposed, seeking 91 amnesty approval. Again, no mention of floats. The board approved the plan unanimously. And then the permit issued December 21, and it again reflects the record, which is to license and maintain an existing bulkhead, and that all work has been done in accordance with the plan. So our contention, based upon that, is that no relief was ever requested for any floats. No notice was given for any floats. The weight of the evidence is that it was only for a bulkhead, and therefore the permit only approved the bulkhead, and did not approve any floats. It's interesting that subsequently, Mr. Augusta did file for the Chapter 91 plan, Chapter 91 license, and they used basically what looks like the same plan, but they changed the reference in the title. And this time they said, to maintain an existing concrete and steel bulkhead and floats. So after the zoning process was completed, they then asked the DEP for permission for the floats. Going back to that timeline, as you could see from all of the documents, the application was filed in July. All the comments came in early to mid-December. The hearing happens December 18th. Thus, all of the town officials that were doing their due diligence on this project were under the understanding that what was being reviewed was the bulkhead. None of them ever reviewed the proposal for floats. And thus, our contention is that the Board of Selectmen, hearing all these comments, seeing the weight of the evidence before them, was in fact knowing that they were approving a bulkhead and did not know they were approving any floats. And under Mr. Hoyt's theory, basically one could thwart the zoning process by submitting an application, going through all the due diligence, and then coming to the hearing and say, oh, I have a plan, and then walk out and say, oh, I got approval for this plan. That's not how it works. It's a public process. Neighbors have the right to see things. Town officials have the right to see things. And basically, on the weight of the evidence and under those zoning principles that I mentioned about the board can act on what's pending before it and not on what's not, what was before the board was a bulkhead, and that's what that permit is about. Mr. Hoyt raised some other arguments at the last hearing, and I'll be brief about these. He talked about the fact that his client's floats might be grandfathered, and so to claim grandfathering, to claim pre-existing non-conforming use, the structures must be lawful to begin with, and so our contention is without a special permit, they weren't lawful to begin with. That then gets you to the statute of limitations. So if one has a structure for 10 years or more, it's immune from zoning enforcement. But one of the critical things to that is that the structure must remain unchanged, because any change becomes subject to the bylaw. And in this case, we have the Chapter 91 license that says 2 floats 6 feet by 16 in size. So presumably those went in because there's a compliance process for Chapter 91. However, at a subsequent point, and Mr. Bayless is here tonight, he can speak to the dates specifically if the board has questions. At a subsequent point, Mr. and Mrs. Dundulis brought these floats in that are shown in the picture, and these are the ones that are shown on that site plan that I showed you a minute ago. These are 8 feet by 20. And so the original floats were taken out, and these ones were put in. But during all of this litigation, because I've mentioned before that Mr. Dundulis has appealed the wetlands permit and has appealed the special permit, during all this process, they changed the floats again, and they put them back to what the Chapter 91 license says and requires. And so thus, there can't be a claim for grandfathering because the structures have changed at least 2 times over the course of time. And this last change was just this spring. And so any claim to prior use was essentially waived, even if they had it. And there are some other technical problems that I won't get into. I did submit a letter outlining all of these, but essentially so-called grandfathering protection goes to structures and uses of land, and I keep referring to the word structure. But these aren't structures, they're floats. They're not affixed to the ground, they float on the water. And they're not attached to Mr. Dundulis's property, they're in waters of the Commonwealth of Massachusetts, and that's why they need a Chapter 91 license. They need permission from the Commonwealth, signed by the governor, to be here. And so they can't be part of the land, and if one reads Chapter 40A, Section 7, protections go to things that run with the land or are on the land. Thirdly, Mr. Hoyt raised an argument about aggrievement. And so essentially, our claim for aggrievement is that starting with the proposition that the Penticus floats were not legal, and our contention is that the Dundulis floats are not legal, there are all these illegal floats at the end of the canal causing overcrowding. And the irony being is that the persons that have the floats without proper permission are claiming that the new proposed dock that has all the proper permits is causing the overcrowding. It's actually quite the reverse. And so if one were to look at this, this is the Penticus property, and Mr. Penticus has 2 boats in front of it with 2 floats. And as I mentioned here, the Dundulises have these floats, and if I note for your attention, this float in the foreground, how close it is to the bulkhead. This is Mr. Bayless's bulkhead.
Attorney Wall, I hate to interrupt, but you are at your 15 minutes. Did you intend on commenting anything else?
Could I have 2 more minutes?
Would the board be so inclined to entertain that?
Yes.
Okay. 2 more
I'll be
minutes.
very brief. Essentially, you can see my argument about the aggrievement. What I wanted to say further about it is that Mr. Bayless has maintained a boat here against his bulkhead, but he's only been able to do that because the space that Mr. Cachadorian now wants to use has been vacant. And so the overcrowding essentially prevents Mr. Bayless and Mr. Cachadorian from having floats along their walls like Penticus and Dundulas have without permits. That's why they went for the perpendicular dock. But that's the one that now Dundulas and Penticus claim will hurt them. And also, that dock is far from certain because it's subject to numerous appeals, and my clients may never get that. So the aggrievement is that Mr. Dundulas is overutilizing his area of his waterfront, as is Mr. Penticus. And what we're simply seeking to do through the process is have everyone go through the public permitting process before the Board of Selectmen and have the Board of Selectmen sort that all out. The last thing that I want to say has to do with the letter that the building commissioner came in. My appeal, or my client's appeal, is termed as an appeal of a de facto denial because we had submitted a request for relief with the building commissioner. He did not respond. We sent a follow-up letter. We still didn't get a response. So we treated it as a de facto denial. And Mr. Hoyt filed a letter that says that without a decision, the board has nothing to review. And he is correct about that. However, it's not that simple. One that seeks to stop the process without a written decision has to assert a timely objection. And he has cited some case law that says without a decision, the board can't proceed. But there is case law that says that it creates a jurisdictional defect that's like personal jurisdiction. So it's not like subject matter where that can never be waived, but personal jurisdiction can be waived. And what happened the last time, as you saw, and I hope you remember, is that Mr. Hoyt came in with a letter and quite a bit of argument. And my contention is that they waived that argument and they participated in the process, and therefore this is not an issue. And I have 2 cases that I can cite, and I'm just gonna scroll down just to show you that I'm not just embellishing this. But here's a quote from the case. It says here, the plaintiffs had the same problem, and it said that the court said it's a jurisdictional issue, and it's rather like a defect of personal jurisdiction. It may be overlooked if not timely objected to. And my argument is that one can't have their cake and eat it too. One can't come before you, argue, and have you ask you to hold that permit that is at issue, granted the floats, and then come back at the continued hearing and say, oh, wait a minute, there's no written hearing, no written decision. You don't have to go forward and you can't go forward. But having said all of that, and I said this because I think this case might end up in court, and therefore I would suggest that the board might want to make findings on this, but it might render it moot because the building commissioner has in fact issued a decision, and the decision is that he's not going to take action. So I think that cured any kind of jurisdictional argument, and I would ask for a finding to that effect. And I would also like to amend my appeal by motion to call it an appeal of a denial rather than a de facto denial. And thank you for the extra time. I'm sorry that I went on. I had a lot to cover. I'm available for any questions. My clients are here. They're available for any questions as well.
Thank you, Attorney Wall. Start with questions. Mary, do you have any questions?
I don't have any questions.
Bob?
Not right now, no.
No.
Ken? No. Jerry?
Not now.
James?
Nope.
All right, and I don't have any questions either right now. Attorney Hoyt, did you intend on speaking tonight? Sure. We'll allow you no more time than Attorney Wall.
Good evening, Mr. Chairman. As I indicated in my letter to the board last week, the case law is clear that until there's a written decision, there is no appealable event. Therefore, the appeal that initiated this hearing was not an appeal that this board had jurisdiction to take up. We don't waive, we didn't waive, we object. I consider our objection to jurisdiction to be timely. If Attorney Wall and the applicants, intend and want to push forward nonetheless, I guess that's their decision and the board's decision as to how to respond. I don't, deliberately did not go through the exercise of responding to each of the points made in Attorney Wall's letter, or and don't intend to do a substantive response to the points he made tonight, although we do certainly have a substantive response when the time comes. To the extent the board were to proceed and issue a decision in this appeal, our position is that whatever that decision is, it would be void as lacking jurisdiction, and that would be the issue in court, assuming it went, if it went, well, that would be the issue in court. We're prepared to address the substance of the issues raised. I would note that separate and apart from the jurisdictional issue, and this it's related, Attorney Wall mentioned that at the time of the initial appeal to the building inspector, the floats that were in place at the Dunderless property at the time were ones that were, in fact, not the right shape and size for what was approved. And that wasn't, deliberate. They had the opportunity to get some floats for a particularly good bargain price at a time when their original floats were, degraded and in need of, they had outlived their useful life. They found some floats to replace them that were affordable, and they put them in, and they gave one of their old floats to Mr. Bayless to allow him to get access to the water. What's interesting is that the October 2018 request to the building inspector for enforcement, the Dunderlesses responded to that by removing the offending floats. The main thrust of the October 2018 letter had to do with the floats being too big. And so the Dunderlesses heard the complaint and responded by taking them out and replacing them. They went out and spent the money to get new floats that returned the configuration to what it had been previously. And it was in the non-conforming configuration for a short time. Certainly less than 2 years. So the point being that beyond the question of jurisdiction and the lack of jurisdiction because there hadn't been a written decision until yesterday, the October 2018 request of the building inspector was made moot, I would argue, by the fact that Dunderlesses responded to it by addressing the substance of the complaint, at least as to the size and location of the floats. Moreover, the point I'm getting at is that what's intended in the statute is that the building commissioner is intended to have first crack at issues raised regarding compliance, and that this board is intended to serve an appellate function. The issues that were presented in the building inspectors, in the letter to the building inspector, none of them are the same issues that are currently being discussed here. In the letter to the building inspector, the question was whether there was any special permit at all. We now, now the question is, does the special permit that we, all now have in front of us, which wasn't in front of the building inspector, what is the scope of that special permit? The question in front of the building inspector at the time was, the size and shape of these floats. Well, the floats then were not the floats now. So none of the issues that the board is being asked now to address have the building inspector, the building commissioner hasn't had a shot to really consider the substance of those issues. So, that's another reason why I would urge the board, not to, proceed and carry forward, but to, to kick this back to the building commissioner and have the building commissioner, I know the building commissioner has responded to the 2018 letter. Part of the reason I raised these issues about everything being moot is that I don't want to, if we come back, if we end up going forward and the issues and the whole procedure is based around the 2018 enforcement letter, I'm going to take the position that the 2018 enforcement request has been made moot by the Dundulis is responding to it by pulling the offending floats that were oversized. So what I think makes the most sense is that the building commissioner should have a chance to address the complaints and issues that are the current ones, not the ones that were in mind in 2018, and we'll respond in due course. If we do not waive the jurisdiction issue, we're happy to argue it in court if that's the way the applicant wants to go with it. But I think that this hearing is proceeding without a jurisdictional basis because the appeal came in before there was ever any written decision. There is now a written decision. I suppose the applicant, if they wanted to, could now file an appeal of it, and we could, come back in whenever to address it. I think it would make more sense for the applicant to write a more current request to the building commissioner and let the building commissioner have a crack at what are the current issues, and then come back to this board and let this board serve its appellate function, at which point, we'd be happy to address and will address all of the, substantive matters that Attorney Wall presented. And I'm sort of loath to leave him hanging out there without a response, but this isn't, it's a hearing where there's not jurisdiction to proceed. So I'll leave it there.
Thank you, Attorney Hoyt. Any questions for Attorney Hoyt? James?
Very good. This is on another case where a similar case was argued, and an attorney refused to discuss the matter before us because they said we did not have jurisdictional, and they wanted that resolved, and they did not want to comment. Now, I don't know if that's their opinion or is a legal fact on proceeding on a jurisdictional issue in front of an appellate board that doesn't have the ability to hear it. As Mr. Wall said, you did come and you provided an eloquent defense. In do so, and it seemed like you might have waived that. That's the first thing, that's what my educator. Personally, I think we just should send this to the courts, because I think if it goes back to the building commission, it's gonna come back to us. And I think Mr. Wall might have said, let the courts handle this, because this is some complex stuff, and there's some
Sure,
tinge issue.
let's hold back on any
Okay,
comment. You have
okay.
Any more questions?
That'll be it.
All right. Ken,
Did he want to respond
Oh, I'm
on the
sorry.
jurisdiction?
if you cared on commenting on that, Attorney Hoyt.
I think where there's a jurisdictional issue which, came to my attention in the, when it came to my attention, I raised it, and it was, the argument, to spend a lot of time in the future arguing about whether, the objection was timely. I'll go that way if that's the way the applicant wants
I
to
think
go.
the question they meant was standing. Did we have a right to listen to anything without standing being approved?
If it goes the way it should, the building commissioner will have a fresh look at what are the current issues, and
Okay.
there will be a new hearing, and you'll base your decision on the evidence that is then presented. But I think the building commissioner should have the first crack at what are the current issues, the scope of the permit, and all the other issues that have been raised. They're not the same issues that were in the 2018 letter.
Anything else, Jerry?
No, thank you.
John?
I guess I'm confused. He's issued a decision, yes?
Yes.
So how does he reconsider? What's the process?
The paths that could go at this point would be for the applicant, I would think, and I guess depending on the applicant's choice, how the board would respond accordingly. The applicant could ask the board to push forward with this hearing, and which is what Attorney Wall has done. Choice 2 would be to use this current written denial, which is under law the event that triggers the right to a hearing. Could use this to then make a fresh appeal, and we'd be back in however, whenever the board was able to get that appeal scheduled. Again, though, I have said I would then get up here and say, well, this response was this letter was in response to an enforcement request that was made when facts were different than what they are now. The floats in place were different than what they are now, and the issues that were the arguments at issue were different than the ones that were presented to the building commissioner. So the third option, I would think the best option, frankly, would be for the applicant to make a current and renewed request to the building commissioner based on current facts and circumstances. The building commissioner obviously is now intending and obviously aware of its need to respond. They'd respond. And then this board would presumably be then brought back into it after the building commissioner had the chance to make a ruling of some kind on the current issues and the current facts. It would take some time, but I think it's seems to me the preferred procedure, but it's not really, I'm not in the driver's seat on it, except to say that we don't waive our jurisdictional objection. Really leaves it to the applicant to decide which among those three paths they want to take, and if they insist, if they push the board to move forward, then the board can decide, and we'll object to any, we reserve our right to argue the jurisdictional issue in court. But we are not, as I said, we're not, having said, we now recognize a jurisdictional defect. We're not going to, try to continue and proceed and argue the substance of it. That.
Okay.
So I guess my question would be, so in your previous packet, you did say because he didn't answer, the building commissioner did not give a written response. The applicant would then have to go for, is it a mandamus action in court to force a response?
Well, I mean, if the building commissioner had continued to just say, to continue to not answer, that is the way that a applicant can force the building commissioner's hand, because it's a non-discretionary duty to make a decision one way or the other, and that's what the case law suggests as the remedy. I mean, the flip side of it seems oddly, why make people go through all that, but the flip side of it is that, on the other hand, until the building commissioner does issue a written decision, the person who requested the enforcement has not, their appeal rights are still alive, right?
So I guess that's what my question is. So your last information you submitted basically said that their only choice without an answer would be for mandamus action, and then if they want to go that way, that's the way they should go, because we wouldn't have jurisdiction. Now we're in receipt tonight of a response, and the applicant has seemed to say that they're going to amend based on the response. So at that point, it doesn't seem like we would have a choice to say we could not go forward, since we now have a written response and the applicant has said they're amending their decision. So is
whether it's characterized as an verbally amended appeal or what have you, provided that, would, to the extent the board is, now being asked to take up an appeal of what is a written decision, then we would, have the right to respond substantively, as if the request had just been made, and at the next hearing, whatever, which would be the equivalent of the first hearing, post-written decision, we'll respond to the substance at that time, if that's sort of like the path B that I was saying. I personally think a better path is to let a building commissioner have the first crack at the new and substantive issues, but that's not, if it's, whether you cast it as an amended appeal or a new appeal based on this written decision, as long as we're given, notice and the opportunity to, make the substantive response, then we will.
Any other questions from the board? Barry, anything? No? Okay. Thank you, Attorney Hoyt. Any members of the public have any questions, comments, concerns regarding this appeal? Sir?
Good evening, Mr. Chairman. My name, and members of the board. My name is Steve Bayless. I'm one of the applicants, I think you could call me, for removal of the offending floats. I live at 64 Muskeget Road in East Falmouth. I've owned the property for almost 8 years now. I'm a full-time resident, have been for a number of years. I wanted to use my 2 minutes, I promise not to go over that, just to clarify a couple of things that were brought up at the first hearing that I think deserve to be clarified. The special permit that we applied for, we failed to carry a supermajority, so that's why we lost that particular hearing. But we didn't lose it 3-2, as I recall, it was 3-1. And I just thought that was a technical matter I wanted the board to understand. Another thing that you might have had the impression from the first hearing was that everything was fine down my end of the canal until my next door neighbor, Mr. Cachadorian, came along, and that really was not the case. For the full 8 years that I've tried to boat down there, I've had to contend with numerous non-owner boats. It's not only the floats. The floats invite people that don't live there, that don't pay property taxes, and my whole life savings is tied up in that property. And I wish to defend my right to boat to my licensed seawall against the interest of people that don't live there, but that are perfectly happy to use one of those floats right in front of me for their extended families and their own enjoyment all season long. It's not only on my side with the Dundolas floats, but it's the same non-owner utilizing a float on the other side, on the Pentecost side. Plus a couple of moorings at the end of the canal. I mean, that's a lot of boating capability, and some of it's coming at my expense. So that adds a little color to what's going on with all those boats you see. As a matter of fact, in that picture that had a lot of boats, the majority of them do not live there. I got to tell you, that's a bit of a hardship. Beyond that, I only wanted to make one other comment, which was Attorney Hoyt said a minute ago that the nonconformity has been going on for maybe around 2 years, and that's not the case. You saw 2 iterations of the Dundulas float structures in this picture that my attorney had up on the board. But prior to that, there was another one that by no means complied with what they contend to be that 91 license. So there's been, in my 8 years, there's been 3 iterations, and all of them have been creating a problem on my access. That's all I wanted to say. Thank you.
Mr. Bayless, any questions for Mr. Bayless?
Yeah, just a quick question. So when you say it's people using them that don't live there, it's same families, right? They're not leasing or renting or?
Oh, it was my contention at a selectman open hearing, so I'll say it here. I don't think anybody gets anything for free waterfront. And I will tell you this, on my side, on the Dundulas float side, when I came onto the scene 8 years ago, there was a very large boat that was right in front of me that was by no means connected to that property. He was an individual that might have lived in Falmouth, as I understand, but certainly didn't live on this canal or anywhere near it.
So the only reason I bring that up is because when the Chapter 91 license was up there that Mr. Wall put out,
Yeah,
I thought I saw a line in there that said, can only be used, it cannot be leased, rented. It seemed very
I'm
specific.
quite sure you saw that because I've seen it plenty of times myself. But I would like to just clarify your question a little bit more. So when it was my understanding that the large boat that used to hem me in, who did not live anywhere near us, until he died, he occupied that spot. Shortly thereafter, again, to fence off any trouble, another boat came in. And that boat that guy at least lives somewhere in the neighborhood. But he also has a boat, on the Pentacus float. So he's got two boats down basically on top of my bulkhead. And it's my understanding he's also got two moorings right at the foot of the canal. So that's why I was trying to tell you, it's a lot of use going on in one family that I think is really coming at my expense, because you've got not only floats coming out, but then you got the beam of a large boat. So I have to come down, almost kiss the seawall, and make a hard left, which is possible on my mediocre skills, but it won't be possible with another boat adjoining my seawall. Thank you.
Thank you. Any other members of the public wishing to make any sort of comment tonight? Sir?
Good evening, everybody. Frank Dundulis, 18 Tashmo Drive. I don't know what to say. You know, I've got 80 feet of seawall. I've now got my two floats there. I've let people stay there for a year or two. What kind of guy would do that? Well, probably the same guy that would give his neighbor a float because he didn't have one. We're generous people. I'm a very lucky person. And Mr. Bayless is over-exaggerating. As a matter of fact, he doesn't even have a boat. The boat I haven't seen all season, yet he keeps this up. I can go 4 feet from the seawall with my dock, but I went 12 to give Mr. Bayless some breathing room. Trying to be a good neighbor, it's just not working out. That's all I got to say. Any questions from me? No?
Any questions for Mr. Dundulis?
Okay, thank you.
Thank you. So, any other members of the public? Sir?
Good evening. My name's Tony Penticus. I live at 5 Cannon Fitzgerald Drive in East Falmouth. I'm across the water from Frank. I just want to make a statement that at times, yes, there was a boat behind me. At no time was there any compensation of any form given to me. I'm sort of like Frank, and my dad was like Frank. We're just nice people helping out other nice people. And that's it, you know? We just let someone use a float or a spot on the bulkhead. And I also pay taxes in Falmouth, a significant amount. So I don't see what the issue is letting someone go on the bulkhead for free. That's all. No compensation.
Thank you. Any questions for Mr.? Thank you. Any other members of the public wish to make any sort of comment regarding this appeal tonight? Okay, seeing none, back to the board.
So if you want to discuss a little bit, so I know we just got this answer from the building commissioner tonight. Most of us just saw it when we came to the hearing.
Right.
And because it did come in so late, I would assume if this does continue, it would be a continuance so that the applicant and the defending party would have time to review and make a proper presentation. I think now that we have received written response, we have jurisdiction, and I don't see how we couldn't go forward now that the applicant has said they're amending it based on this response. So if we wanted to proceed, I would suggest continuing to another date to give all parties time to review all their information, and then just make whatever proper presentation that they have at that time.
Sounds reasonable to me.
Tend to agree with you.
I would agree, but I thought Mr. Hoyt had sort of said, in his mind, he'll come back and rebuff, maybe he didn't use the word, answer the issues brought up by Attorney Wall.
No, I think he did, but I think he was also giving us another option to say, we just end this now, wait till there's another application.
Yeah, but I see in some respects the merits, but I think next week we're gonna have another dueling set of lawyers' comments. We might have to go back to town council to see if we need guidance on it. So I guess I'm in between on continuing this, because I still think this is going to end up someplace other than here.
I think we need to give them a chance to respond to the letter.
Well, I think the answer from the building commissioner, regardless now, throws it in our court to proceed. I wouldn't want to end it tonight, because you want to give parties the chance to respond. And this information came in late, but whenever we've gotten these responses from the building commissioner, I mean, I think at that point, it's thrown in our jurisdiction, and we have to.
But Mr. Hoyt, through you, Chair, Mr. Chair, Mr. Hoyt had said that he has no, he gave us 3 options. We know what his preference was, but he didn't insist we take it. He said these are the 2 or 3. He'd prefer course of action A, but we could go B. So I'm not sure, other than allowing a far more formal response to come in, what substantive difference we're gonna get.
Jurisdiction. Right now, the argument is we don't have jurisdiction. So anything that we've heard of. So I think with this basis, we now have jurisdiction. So now we have to have a formal hearing
that's the
based on this.
So that's the reason.
The
to continue.
jurisdiction, yeah.
Okay, I missed that.
But the building commissioner's denial, according to the letter, if I read it correctly, was based on the fact there wasn't sufficient documentation about the,
Right.
the nature of the floats and all that. There was no plot plan, there was all that. It seems likely to me that if that's, first of all, we've seen all that stuff now from Mr. Wall, but the building commissioner was not presented with this, right?
Yes.
I think I'd ask Attorney Wall what he submitted to the building department.
Well, that's fair. Let's do that.
Attorney Wall?
Because that was the argument the building commissioner made in his letter. And you certainly supplied plenty of background information
Yeah,
to
this
us.
is the.
No attachments.
Thank you for the opportunity. So, two points about that. There was an argument that it's become moot because the floats have been returned. And the second argument is about the building commissioner. What was presented to him is not what's before you. And neither of those are I would disagree with, are relevant. The request was very simple. It said there are floats in the water that don't have a permit. So why he needs plans and things like that, it's simply a matter of determining whether there's a permit or not. So I think the board has a tough choice. I would recommend 2 potential courses of action. One is, as I wrapped up my presentation, I cited some case law that said when an applicant, when there's a person that's the subject of a request for enforcement, they can take the position that without a written decision, there's no jurisdiction. And I think Mr. Potempus was talking about an attorney who was doing that, with basically saying, I'm here, but I'm not here to talk about it, I'm only here to talk about jurisdiction. And without restating everything, you remember Mr. Hoyt came with a letter and said a lot of things at the podium, as did Mr. Dundoulis, and Mr. Dundoulis just got up and said more. And so I think the board could proceed on the initial appeal on the grounds that any jurisdictional argument was waived. And that case law gives you the authority to make that determination, so you can make findings about that. The alternative would be to continue this, and I would submit that you should continue it for maybe 30 to 45 days, because I think that Mr. Hoyt is correct, that the building commissioner's decision creates a new appellate right. And so now we're kind of in this parallel appeal process. And with all the time that the board has spent, if we go off to court and it doesn't get resolved, and we come back here a year later, some of the faces might be different. So what I'm thinking is, if we continue it to, say, 45 days, I'll file a new appeal of the new decision, and I'll get up to the podium and I'll just say, remember everything I said last time? Say it again.
Promise you'll just say that,
And I'll
nothing
sit,
more?
sit down. Because the appeal to court is de novo, so it's not like I have to create a record or anything, and then you'll have an appeal of a de facto denial, and then you'll have a decision, and again, the only question before you, and I say this respectfully, of course, is that, is there a special permit for those floats or not? Because that whole argument about the request was about the big floats, and then they were taken out, and then it's the small floats. Well, no, the small floats don't have a permit. And so it's a question of, is there a permit or is there not a permit? And you've got all the evidence to make that case.
So, follow-up question. So those are two alternatives. One, the first alternative you mentioned, the jurisdictional argument, just seems like a fuzzier part of the law to me, but I'm not a lawyer, whereas the continuation seems like a cleaner solution.
Yeah, and
Comment?
there's a lot invested in this because I referred to other things. And so I think if you play that scenario out, Mr. Foreman, if we come back in 45 days and there's another appeal pending, the board could theoretically grant both of them without being presumptuous if that's what you decided to do. But yeah, there's a lot of litigation going on, and I'd rather get it right.
Well, then I would move we continue.
I second.
And what's in the 45 days isn't a problem, because we're at what, January?
We'd be looking at January 23rd, because we have a lot of cases.
So January 23rd?
I would move we continue to January 23rd,
Second.
6:30 here in Town Hall.
Do we want to hear from Mr. Hoyt or?
No.
I don't think that's
No, okay.
necessary.
No,
All
we'll
right,
just
so motion
continue.
to continue this
If they're
hearing to
available.
January 23rd, 2020. Is there a second?
Second.
6:30 here at Town Hall, second by Ed. All those in favor?
Aye.
Aye.
Thank you.
There was nothing for, back for here, right?
No, not
No,
during,
no.
not during our hearing.
It was great, but I didn't say anything.
All right, that leaves us with our last application for the night, I think. It's application 58-19, DeSangro, 26, 30, 36, and 40 Crooked Meadow Road in Hatfield. And for the applicant tonight?
The applicant, Nick Marioni, representing the applicant. At the last meeting, there was some comments from the board, mostly involving engineering and landscaping. And we were sent off to address those concerns. We've since done that, met with the neighbors, we've addressed the erosion and sediment control issues. And we have comments back from engineering as a result of that. And Mike Borselli is gonna come up now and explain step by step those engineering changes for you.
Mr. Chairman, members of the board, good evening. For the record, my name is Michael Borselli, Falmouth Engineering, and I represent the applicant. Just to refresh your memory, we've had one public hearing on this case, and that hearing was continued so that we could review and respond to comments from engineering that had come in without sufficient time to review and revise plans. We've had 2 working meetings with Town of Falmouth engineering staff. We've submitted revised plans to you. We've submitted a letter to you that summarizes some of the issues that were raised about specifically coastal pond overlay districts and Zone 2's 2 municipal water supplies. Very recently, I think it was dated yesterday, the engineering department issued a second comment letter that is a result of his review of the revised plans from the initial meeting. And I'll basically paraphrase that. That report said that we had addressed all the issues and concerns with some minor things that he suggested could be conditions of your approval. One of which was relative to the erosion control plan, where he wanted the limit of work adjusted slightly. So you have in your package revised plans, including the erosion control plan, that sets out specifications on how to address any potential erosion controls on the site. And that is this plan before you in your package. It shows a limit of work around the entire perimeter of the property. One of the comments was from engineering that he suggested that perhaps it should be continued along the frontage of the lot, with the exception of the construction access points that you can see shaded here. So that's certainly something that we could accept as a condition. The initial report from engineering had wanted us to identify site distances on the plans, which we have shown on the revised plan that's in your package. There's text on the plan in orange color that shows the site distances looking towards the west and towards the east on both driveways that are proposed for the site. And this plan that's colored shows these safe site distances that were determined to be adequate by the engineering department. There were some drainage changes that were made subsequent to the initial hearing. Some other minor revisions to the plan included labeling the separation distances between the buildings. We surveyed, if you look at the bottom of the plan, we surveyed the areas of alteration on the abutting property. So you'll see clearing lines. This squiggly line represents what has been cleared on the abutting properties. In fact, it shows in this area that there was actually clearing over the applicant's property line encroaching into our site. Along the power line easement, you can see the edge of clearing. So in response to these additional survey measurements and additions to the plan, the landscape plan was revised to provide screening through fencing and landscape features on the site to do what we thought we could to buffer the surrounding areas.
Could you point out the fencing?
Fencing, I believe, is shown on the landscape plan. So the landscape plan,
I mean, if anybody's,
No, I'm with you, Jerry, because there was a comment about that in the
yeah,
letter.
that's right.
the fencing is shown on this landscape plan. If you look at the bottom, see it says start privacy fence, and it runs along the entire back of the property with the exception of this corner, where the landscaping is proposed to be dense and thick. On this side, there is existing vegetation that is naturally occurring.
And how tall is that fence?
It says 6 foot high, Vinyl fence, 6 foot high, 2 foot off the property line. In addition to this plan that was submitted and the revisions to the site plans, just for a clarification, we prepared an illustrated plan that shows certain resources neighborhood-wide, some of the things that you may be concerned about, and I'll point those out. First of all, this bold green line and everything to the west is the Great Pond Coastal Pond Overlay District. The blue perimeter is the 4 lots that we're developing, so we are not in a coastal pond overlay district. This purple line and everything west to it is the Zone 2, DEP designated Zone 2 to a municipal water supply. At the bottom of the page, at the very bottom, you'll see some red areas, and you'll see Zone C. In the letter I submitted, I talked about Long Pond and a map that identifies surface water protection areas, and they're designated A, B, and C, A being the most sensitive, and it's 400 feet from the waters of Long Pond. It's all entirely on Town of Falmouth municipally owned land. So of course, and that doesn't even show up on the page, and then the next outer zone is Zone B, and then the very northern tips of Zone C are shown here. For reference, this gray area is the most northern part of the Falmouth High School. So you can see where we are relative to that. Title V systems are allowed in Zone C. So we're significantly far distance from all of the surface water protection areas for Long Pond. We're not within a coastal pond overlay district, and we're not within a Zone 2. So we believe that the project and its wastewater system is adequate as proposed. If you look at the second report from the town engineer, he goes through section by section with recommendations, and we looked at all the recommendations appear to be reasonable with the exception of a few that I would allow Mr. Marioni to speak to. So I'm here to answer questions about the revised site plans.
Any questions? Mary?
I have no questions.
Bob?
Just one question. I think when we were last here, Ken Foreman brought up the situation of trying to move those 2 middle buildings closer together where they were so tight on the front corners.
Can you clarify your question, please?
So the 2 middle buildings at the bottom,
These here, yes?
Building 3 and 4.
3 and 4?
Yes,
Have 20.8 feet, or 20.8 feet of separation.
yes.
Like 11 on one
Building 4
side
and
and-
5 have 11 feet.
So I think
Yes.
we're going to try to move them close together to give more space on the sides.
This space between these 2 buildings could certainly be reduced if that was the,
So that you get more distance from the other corners.
and then these would be further spaced apart by some distance. They could probably, on average, be 15 feet apart instead of a couple being 11 and a couple being 20. That's certainly doable, but I didn't understand that to be a significant concern, but it can certainly be done. We'd have to shift around the parking spaces as well, just to be in front of the buildings after they're shifted, but it's certainly doable.
Anything else?
That's the only question on the engineering.
Nothing.
Ken?
No,
Oh, I'm sorry.
no, nothing now.
Ken?
Well, that's the one thing I noticed, I guess. I mean, they've addressed with landscaping in the fence, some of the buffering issues, right?
Mm-hmm. Jerry, anything?
Nothing right now.
James? All right. Any members of the public have any questions, comments, concerns regarding this project?
is Diane Wells, and I live at 47 Crooked Meadow Road. I don't have an opposition so much to the project, but it's too dense for our area. The increased traffic, the increased noise, the danger to the kids who are who live on the street. I mean, they're just trying to squeeze in too much in such a small area. I don't know if you know our neighborhood. Mr. DeSangro, when we explained this to him and thought, maybe a compromise would be making it a smaller project, his comment was, I don't make any money that way. Our neighborhood is quiet, we're tight-knit, and we care about one another. But the way this project is kind of being forced down our throats in a very tight area, that's the problem. And it's not the 40B. I mean, that's how they've gotten it under the radar. What my concern is, it's too much in too small an area. And during the summer, Crooked Meadow Road is a cut-through. And with all these extra units and all the extra, activity, I'm really concerned. I mean, I bought my house knowing that there was free area across the street, but not to have this and then his plan for a single-family house on the corner on top of it all. I just think it's too much.
Thank you, Ms. Wells. Does anyone else have any other questions, comments, concerns regarding this project, sir?
Thank you. Timothy Smith. I'm on a butter. I'm on Deer Pond Road, directly behind 3 and 4. Just to kind of follow suit with the previous speaker, I recently read in a article with the Cape Cod Times something that is being echoed by us, that was brought up by Mr. Dugan on the 8th, that was brought up in the Cape Cod Times, and this was regarding the Pheasant Lane project, even though, obviously the 40B is a whole different animal. But Mr. Dugan at that time argued a change in density in a neighborhood caused by the addition of a single house could represent harm, along with the reduction of open space and increased traffic. So here we are discussing the same thing. Again, the project is what it is, 40B. It allows the development of this particular property, but the amount of structures that are on the property and the density and everything that was just said is still a big concern for all of us. I appreciate that Mr. Marioni has, reached out to the neighbors. There was a second revision on the landscape design. It was sent out to us on the 18th. I have seen a little bit of it and haven't really had time to make a lot of notes and and send anything back to Mr. Marioni. And I hope that we'll continue to discuss this in earnest. But, as the project goes along and the process goes along with you, I just still ask for the support of the ZBA, and in particular, just reading that article, those comments, that, the density is a big issue. And, again, if you had the opportunity to look at, our property, look at the photos, look at the lot lines, the encroachment is quite substantial. So, again, we just wanted to I wanted to, at least for myself, put out the opposition out there, and if anything, as this goes further, if there is some discussion amongst yourselves about a reduction in the property, I also concur and, would ask for your consideration. Thank you.
Thank you, Mr. Smith. Anyone else care to make any comment or have any questions tonight? I do. Ma'am? There's time for both of you, no problem.
Good evening. My name is Jeffrey Felty. I am Diane's husband. I live at 47 Crooked Meadow, right there on the corner, as you can see on the plan. There's just too much traffic. It's just too big for the neighborhood. Stop in sometime. Take a drive through. Check it out. You'll see that this project is just too much for the area. They're trying to square peg. Thank you.
Thank you. Ma'am?
Michelle Royer, 495 Blacksmith Shop Road. You kind of asked my question for me. Do you, as a group, as a board, or individually, ever go and physically look at these sites?
We do.
Rather.
And
You
I,
do.
for one, am very familiar with with that location.
All right, so that figures into, obviously, your impression of the project and so forth.
It does. We usually do site visits on every application that we receive.
Thank you.
It's individual. We don't go out as a group, but we
I
do,
understand that.
we do go out.
Thank you.
Thank you. And just so everyone knows, typically with, as requirements for projects, they're usually staked, so we can go out and see, go out to the location, see where the buildings are proposed compared to sidelines and things of that nature. So it's requirements that we have for 40B applications and other applications that you saw tonight as well. Anyone else out there have any other questions, comments, concerns?
My name is Dan Hallinan. I live right behind this. If I were to buy this property, which I wanted to do, didn't have the money, I wanted to put a garden in there. But now this has arrived. If I had bought it and I wanted to build a project like this, I would not be allowed to do this because I'm not one of these 40B generators. So I would request that you cut the project down to where you don't have such an intense number of buildings right behind me, packed in there. Like the previous speaker says, a great neighborhood. I'm afraid the direction that it's going in, and it's apparently been allowed by political maneuvering so that we can have this 40B insanity going on in a nice neighborhood. I realize that I'm butting up against City Hall, but that's my sentiments. So forgive me for not being a public speaker, and thank you for your time. Do what you can for us, please.
Thank you, sir. Anyone else, sir?
Good evening, Chris Foe, 493 Blacksmith Shop Road. I did submit a letter to the board, and my comments weren't specific to the site, they were more holistic, saying, basically, we see individual applications for 40Bs, I don't want to say frequently. I guess my question is, how are we addressing these holistically? How are we addressing not just the cumulative impact, the need? Because as I sat here, and the day I wrote my letter, there was 25 homes under $250,000 for sale in the town of Falmouth. There was 2 and another 40B that hadn't even been applied for, and so far have not yet been sold. And as I look at the town's Affordable Housing Committee, the Housing Production Plan, it seems to stress that they're looking towards the fact that Falmouth is drawing older folks, looking for smaller homes and smaller communities. This doesn't seem to be addressing the needs of the community, simply the needs of the developer. So is there a plan to look at this more holistically? You know, on an annual basis, sit down and go, okay, these are the applicants we want, and this is how we're gonna meet our 10% goal, because it doesn't seem to be. It seems to be just one at a time, piecemeal, and I don't think if we do it that way, we will ever achieve the goal that we want. Thank you.
Thank you. Anyone else? Okay, back to the board.
Couple questions that, triggered by some of the comments. Was there a traffic study done?
No,
Why not?
it's a 12-unit project. It's just
But
typically
we've
not
heard
required
testimony
for
that there's
something that's
concerns
small.
about traffic, so I'm just wondering.
No, the traffic study was not done.
Is there a sidewalk proposed, other than the little sidewalks that go out to the street from each unit?
In front of the buildings is, one of the waivers we requested was a sidewalk because it was continuously broken by the parking areas and the walkways between buildings. So within the project, there is not a sidewalk proposed.
And what is happening in this center area? I see that's where your leach field is, but is that over the top of it? Is that just lawn, or is it, can you maybe go back to the landscape?
This is supposed to be a lawn area, just to give us an area for activities. You know, the kids throw a ball back and forth. We put a berm out by the street here. We were asked in the engineering comments to move our landscaping and the berm off of the right-of-way of Crooked Meadow Road, which we've done. So it's all on our property now, and it's designed with a berm there so that if a ball were to roll that way, it would stop before it got to the street. And there's two parking spaces here, 2 guest parking spaces there, and 2 guest parking
Well, I'm
spaces
sorry, I
there.
don't see where you're pointing. Oh, okay, now I see them. Yeah. Parallel spaces.
Yes.
Between unit 3 and 4, is that also another guest space?
It is, but I think that's where we're gonna put the mailbox, so it's gonna eliminate that space.
What's
And-
the deal on trash? Is it individual?
Trash is to be picked up by the town, and so right on the sides of each building here, we have a little fenced area to put the tote, plastic wheel tote, which they'll take out to the curb out here
I think we
weekly,
covered,
and the
yeah,
town
we
will
did
come
talk.
and pick it
I've
up.
seen a couple of these now, yeah, okay.
Was there any consideration of reducing the size of the project?
I'm sorry?
Was there any consideration reducing the size of the project?
We certainly looked at it, it just, you know, economically, that's what we need to make it work. You've seen the pro forma. It's not, I don't think we're anywhere near the 20%.
And did you give any consideration to Fallon's housing production plan? Did you review that at all, or?
Yeah, we did. And we understand that they have needs for smaller units. These are all 3-bedroom. We understand that there's needs for 2s and even smaller units. There's some single-room occupancy that they need. There's some 1-bedrooms that are needed. This project, we think, addresses the 3-bedroom requirement. As you
So-
know, we have some others that do have 2-bedroom units in them.
So in this project, then, you chose not to consider the need for the 1 and 2s?
No, it's not that we didn't consider the need. The price point on this one is in the low threes, $329,900 to $339,900, we think is our price point. The 2-bedroom units sell for significantly less than that. And we're in the 15 to 20% range on the profit with the price point we're at with the 3-bedroom units. To build the 2-bedroom units, the cost does not go down significantly because the fixed elements, kitchen, bathrooms, heating systems, septic system, all those things remain the same. You're just cutting the square footage down a little bit and saving a door for a bedroom. So we did look at 2 bedrooms. They're very popular now. They just don't sell for the same price.
So I have some concern about the traffic generation, just because of Crooked Meadow Road, and if we're not looking at being able to change the number of units, that I would suggest that we eliminate the 7, or I guess 6 guest parking spaces to try to limit the traffic generation in and out. Each unit would still be allowed 2 spaces. They could have their own space and a guest space. But adding those other guest spaces in a project this size at this density is going to increase the traffic generation on that road. And without eliminating building issues, I think that would be the best way to try to affect some of the traffic generation. It's just a very narrow road. Crooked Meadows are just a tough road.
Yeah, I don't have any objection to taking out the guest parking spaces. I think
You
2
know, that
per
would
unit
add
is plenty.
ability to do a little more green space or change the area a bit. I do have another question for you, but it's not regarding the general plan. So in the file, you submitted the Sandpoint Shores Association letter?
Yes.
You submitted regarding the dues?
Yes.
There is an error actually in there, they probably don't even know, but, so according to Sandpoint Shores, that they would like you to make this part of the HOA's fee and impound a monthly fee per unit each year by June 1st of $12.50, so it doesn't, so that this would not allow a unit owner not to join the association, is that correct?
That's the way we intended to set up our condo association, was to collect it monthly and make it mandatory.
And right now, your arrears, it said that you'd be in arrears right now of $1,600, which would have to be paid. They actually made an error, it's actually $1,800. By June 2020, it would be $2,400, so is that something the developer is paying out front?
It's not something we're paying. We've been speaking with the seller about that. The seller has sent a letter through his broker to us. I'd be happy to forward that to the board, but he insists that it's not mandatory. This is his opinion, not mine. That it's not mandatory that he would be required to join the association. It's just if you don't pay your dues and you don't join, you're not entitled to use the services. Now,
So
that's
are
an
you-
argument between him and the seller. We would love to join the association.
Well, I think it's more of an ownership situation. So if you have property that you own there with Sandpoint Shores, and you ever want to join the association, you have to pay the dues and arrears per what the original lots were. So in this case, it would be 4. So you'd owe $150 a year right now for 17, 18, 19 per each lot, which is 4. So you basically would owe $600 a year right now for the 3 years through 2019. If the project isn't done by June 1st of 2020, you'd have to pay $2,400. If you don't, none of these units could ever join the association. But it appears if you choose to join the association, what the association is requesting is at that point, every unit would always have to pay monthly fees by June 1st. Individual owners could not opt out.
Well, no, our individual owners would not be, we wouldn't let them opt out. We
You
would
can't.
make it
If you
mandatory.
join this, you can't. You don't have a choice. You either join the association up front, and if you do, from that point on, they're all responsible for those dues, or you don't join the association, and nobody can join the association. So my question is, I assume you're planning on joining the association?
We are.
So if you do, the $2,400 that will be due for the arrears payment, due by June 1st, 2020, would you be paying that, or would you be trying to push that off onto the condo ownership?
No, we don't intend to pay it. We're not trying to push it off on the condo ownership. We're trying to get the person who's selling us the land, who owes the money, who hasn't paid it for the past several years, to pay it as part of the closing, and he's insisting that he doesn't owe it because it's not a requirement.
It's not a
And
requirement.
that's not between me and.
Nope, it's not a requirement for him. It's a requirement according to a letter from the Sandpoint Shores Association, that once you're the owner of property there, and now you develop, and now you decide that you want to have access and the ability to join, that the current owner first has to pay all the dues that are in arrears by June 1st, or whatever that current year is. Once those dues are paid in advance, then yearly bills will go out, in this case, to your condo association. In this case, if you choose to do that, the condo association is saying then every single unit owner will have to each year pay $150, and they're requiring that be impounded through your HOA fees. So what I'm trying to understand is, do you plan to join the association? Because if so, we have to figure that in. Or don't you plan to join the association?
I'm really not sure where you're going with this. Are you trying to
I'm trying
lobby
to
to collect the back money that's owed?
I'm
Or are you
to
trying
find
to
out
make sure
on the-
we
if
pay
you-
going
If you
forward?
choose to join the association, who is paying the arrears payments? Will you be paying them, and then the owners will just pay the $150 a year going forward? Or will you be looking for that fee to be made up by the buyers of the condos?
Neither. I expect either the money will get paid by the person that owes the money, which is the previous owner.
It only is paid if you join. So it's not a requirement to sell the property, it's a requirement to join the association. The previous owner decides he isn't a member of the association, he never has to pay it. If you now choose to develop property and you want to take advantage of the association, that's when they require the payment.
Well, that could create a problem.
And so that's why I'm asking, because that's what their letter says, and that's the letter that was stated by them that was sent in. The only error in it is it says that right now you'd have to pay $1,600, when you actually have to pay $1,800, they missed the payment. And then next year by June 1st, because when you're doing your HOA computations and your condo fees, Sandpoint Shores requires that month, that yearly payment due by June 1st, no later. So those payments would have to be increased in your first 5 months to pay that out. And then your payments would drop. I don't know how you're handling that. So that's what I was trying to find out. How is
Well,
that being handled?
if that can't be negotiated, because we have no intention of paying his back money. So if
It's-
that
it's-
can't be
yeah.
negotiated and they won't allow us to join the association, we probably won't be joining the
So
association.
that's what I just want to know. So
Yeah.
at this point, unless he pays the portion through this year, you have no plans on trying to join the association?
I would then plan to try and negotiate something with the Sandpoint Shores Homeowners Association.
It's their rules and regulations, so it isn't, it's not really a negotiation thing. They basically give you one choice. If you develop the property, when you develop it, they give you a choice. Would you like to join our association, yes or no? If it's yes, they assess for each year, they can go back 3 years. They assess that amount, which they will require to be paid up in advance. And then from that point on, in the case of their letter, every unit owner would be required to pay $150 a year, each unit. Right now, you only have to pay it for the 4 lots. You develop this into the amount of units you are, at that point, every unit is paying $150 a year.
Clarification. And I don't find it interesting, but who's to say this, the Sandcastle Association won't amend their regulations? Right now.
Well, so far.
Is it, I don't know if it's a covenant or not. They may be able to.
Yeah, so they've sent him a letter that's in the file that says, if you.
I know that.
Yeah, so they've said, here's your choice if you chose to join our association.
And he said it'll either be no or renegotiate. If they can't renegotiate, it's gonna be no.
So the reason
And
I'm
they may
trying
be
to-
able to renegotiate.
So my guess would be no, but whatever they try, because I've sold it plus in the area and I
Oh,
know how
okay.
the association is. But I'm just trying to find out is, if they are gonna join, would they be paying the arrears payment, or are they also requiring that as another payment? Because you're talking about affordable units, and if they choose to join, those units cannot choose not to pay
I
an
think-
extra $150 a year.
I think he answered that. He says they don't intend to join unless Sandpoint Shores, and we can put that in the condition. He's testified that they would maybe restate what the ultimatum, well, before you, yeah, not all the
Comment I
condition,
made previously?
is you can refuse to have this project join the Sandpoint Shores, and then they'd never be able to.
It's not a large fee for developer for what
Yeah.
you're gonna get from it, and I think it's a plus for the project.
I do
My
too.
concern is the extra money the affordable units are gonna have to pay every single year without a choice by June 1st. I don't know if they can force you to impound the way they did, I have no idea, but if it is, that's a cost that's going towards an
Well,
affordable unit.
is this complex gonna have any kind of association of its own?
Condominium association.
Right.
Sorry.
Just a condominium association.
Is there a fee associated with that?
Oh, yeah,
Yeah, it was
they'll
in
snow plowing and
Right.
lawn maintenance and other condo.
Now there's two.
And reserves for the septic system and,
Do you have any idea, I don't know if you've done the condo docs yet, what the condo fees are gonna run? Have you run those yet?
we did, and in our pro forma, I think we gave a basic outline of what the fees and the reserves would be.
$192.50 a month according to.
Which included, that included the $12.50 a month for the Sandpoint Shores due.
For just the first 6 months?
No, we did an annualized, for the board, in our submittal, we did an annualized budget showing upon completion that this is what it would cost a homeowner when they moved in. $192.50.
So it's buried in the condo fee?
Buried, it's included in it, it's, yeah, included in it.
Chair, through you, to Bob, and maybe for the rest.
I believe it's stated clearly in it.
I'm sure it is. And maybe through the applicant, maybe we should continue this until we find out what the Sandpoint Shores
No, I don't think it's a major point.
You don't think it's an important point?
I don't think it's that important.
Oh, okay.
I think it's something we can work out with the Sandpoint Shores Homeowners Association. We desire to take them up on their invitation to join. The hang-up seems to be the previous owner, who has a different attitude towards the value of that than we do. And somewhere along the line, we'll figure that out with the Sandpoint Shores Homeowners Association. I don't think we need the ZBA to get
Just trying to
involved
give
in
you the
it.
benefit of the doubt that
I think
you might only get, you need 4 votes, and if Bob's voting no.
Well, no, I'm not saying I'm voting no, I just want to make sure that the condo fee that they're proposing is including that amount. 'Cause if it isn't,
It is.
it's an addition that we have to worry
It's
about.
not including the arrears portion, is what he's saying, right?
Yes.
So he's gonna battle with the seller to get that worked out. I don't think it's, how much is it? $1,800?
No, I just wanted to make sure that that fee, the extra 150
24.
a year, is figured in for the affordable
2400.
unit.
It's 600, is it 600 times
See, in most
4
cases, you
units?
can
on a-
choose not to join.
I think
if you
it's
don't want to.
150 a
In this
year
case, it's different.
for 4 lots for 3 years. So it's 1,800, but it's gonna be 2,400.
Can't believe he's gonna forego the whole thing.
I can't believe it.
I'm just telling you what his letter through the broker, and he said, when we asked him to include it at the closing.
We could put it a condition, one way or the other. I'm sorry.
No, as long as it's figured in, I just want to make sure it's figured in, that's all.
I'm more concerned about the traffic issue. I know it's a small development, but let's say, what do we typically assume, 10 trips per day per unit? So we got 120 trips. What is it? 5 trips per day?
I'm not a traffic engineer, but I don't believe it's 10 trips a day. That
5,
seems
if
excessive.
it's 5 out and 5 back?
I can't speak to the trip generation, but it may be, round trips possibly, but I don't know the answer, so I
I
don't
just
wanna.
have that recollection from single-family
Yeah.
homes, something like that.
Yeah, we'd have to,
right?
we'd have to look into that. I wouldn't wanna say.
So maybe
I
can
think we
answer
ought to
that.
get some
That's
information on
Yeah.
that, because that's been raised as an issue, and how that compares with, the traffic on Crooked Pond Road.
And any police accident reports,
Sure.
unless that's included in the standard trip generation.
Well, I don't think it is,
I don't-
necessarily.
Well, the neighbor's saying it's an issue. Sometimes the police have reports.
No, I mean, I'm not saying it's not a good idea to get the information.
Oh, okay, so it'd be in addition to.
Any other questions for the applicant? No? Okay.
Excuse me. Could I speak?
Briefly.
This project is way too big for this neighborhood. You're saying it's a little project? It's not a little project in the space that it's in. It is a large project for the space that it's in. Take another look, and I think that you'll agree with me. The traffic, they didn't do a traffic assessment. Excuse me, if you did a traffic assessment, you would find that it's just too much. It's too much traffic. It's bad now. It's very bad now. Pulling out of our driveway is an adventure, a daily adventure. So think about it. Thank you.
Thank you, sir.
When is the next hearing?
It's gonna have to be December, I mean,
Is it 2 weeks from today?
no, I think it's, I think it's,
I
Middle
defer
of
to
January.
Noreen on that.
I don't think it's December 12th, I think we're full.
January 23rd?
The ninth?
January 9th? January 9th.
It's continued to January. That's the next public hearing?
The earliest possible.
No, it's a big thing.
Guess I have that too.
The next public hearings are the 5th, December 5th and 12th, but they're very busy nights.
Yeah, we can't convene.
All we would propose to do on that night would be to submit trip generation numbers. If we had 2 weeks, we really couldn't go into January. Our extension is through December.
December 12th. There's only one thing on there.
So
It's a 40.
If they're just gonna
Yeah,
submit
but if
traffic.
they're just submitting traffic on that night.
So we wouldn't be offering any testimony other than to submit that night.
Well, the neighbors might have some, and we have to go through each condition, right, for the 40B?
No.
Well, we're not necessarily
Well, we're not-
proposing
what do we
to
waive?
vote
We're
it
not-
then.
We're not closing or voting, yeah,
Oh,
we're just
okay.
continuing the hearing for
And-
trip
And
generation.
there's only a couple of waivers anyways, if I remember correctly.
So it would be,
But just as an aside thing, just so we know, even if we did that December 12th, and we then had to do the final vote on the January 9th, you're still gonna need an extension anyways on your agreement, because your agreement only extended to December 30th.
If you can hear us no later than the 12th, I may be able to get an extension into January. What you saw what the last one cost us. It's got a gun to our head.
Put them on the 12th.
So we can try for the 12th.
Okay,
We'll see how it
we'll
goes
try
with
for the
the
12th.
12th.
Would anyone like to make a motion to that effect?
So I'd make a motion to continue to December 12th.
Second it.
All right, motion was made by Bob and second by Ed. All those in favor?
Aye.
Aye.
Thank you.
I'd like to say one thing.
Oh, the hearing's closed, sir.
Oh, it is? Oh, well, this was just an invitation for the whole bunch of you to come over to my house before noon someday, and I will give you the flavor of the neighborhood.
Thank you, sir.
you having snacks? Okay.
We'll just give it a quick second for everyone to clear out, because I dealt there here for our open meeting items.
He's got two, he's got the 14 unit.
Is there anything more down there?
I'm saving this.
Okay.
You want this?
No, you can keep this.
Yeah, I did know.
Actually, you're gonna have to set this up.
Ooh,
Section building two.
Make you stay all night and refold them.
Oh, what is this one?
Building two, you just click on,
oh,
then you gotta
I
run
knew
to
there was a contract.
Thank you.
Are you up now?
Are these bourbon filled?
I wish, yes, we can read them there.
Get the view, grocery store.
Can we vote the minutes first? Is that
two
possible?
of them fell out. I never liked the green.
Okay. October 17th, okay?
Maybe it's just the horse throw.
Is this the one we
This is
started to do?
correct.
Right, this is the one I had in mind.
So most of the conditions are voted, but there's been a few
Did you
changes,
indicate-
You have to
so-
speak in the mic now.
Did you indicate which ones were voted here?
Yeah, it's back. We have to vote each one.
All right, first on the open meetings, we'll just take the voting the minutes. I think the October 17th ones were sent out.
Okay, so my mistake, but I haven't reviewed either one, so.
November has not gone yet.
November has not gone out, on October 17th.
And I haven't looked at October 17th.
Maybe it's best to just table it
Yeah.
if. So we will table both minutes of October 17th and November 7th. Up next, we have a discussion draft decision with possible vote on application 20-19 Miwad 0 and 213 North Falmouth Highway in North Falmouth. Maureen circulated an updated draft of the decision. And I know during our last meeting, we voted on some conditions, and
Is the underline new?
Yes, so the underlined items are new. They're, within the findings are primarily additional information or information replies from the board. We've also had some input from engineering, and some of their comments appear in the findings and conditions.
Yeah, so quite a few of these conditions we did vote.
Yes,
We did.
so I have marked on my copy, but not on yours, which
Right.
ones we have yet to vote on. So the first one would be number 3. The developer had stated that they did not intend to do any blasting, but there was some comments about providing for blasting should it become an issue.
Okay.
So that's just pretty standard.
You want
As
to vote
per-
Should we
now?
vote on each one of these now, while we go over it?
sure, so condition 3 says if blasting is required, abutters shall receive prior notice and state protocol shall be followed regarding pre-blast surveys and regulations required by the town of Falmouth Fire Department. Prior notification shall also be provided to the building commissioner and the zoning board of appeals. And as Noreen said, that's standard language. And if we're all set to vote on that, we can.
Yes.
And I don't know if I have the voting members on this.
I'm not a voting member because I missed the summer.
I
So the-
am.
Yeah, so the voting members,
I am.
it's the regular, except Jerry, and Mary took Jerry's place.
Okay, so Mary, Bob, Ed, myself, and
And Ken.
Ken. All right, so all those in favor?
Aye.
Aye.
Okay, your next, item 8, you had already voted about the construction hours. This was merely a little bit of a wordsmithing. It doesn't in any way substantively change what you voted. If you want to revote the language, you're welcome to, but
We're better just to revote it, just in case.
Sure, so the added language is construction vehicles are prohibited from,
Mm-hmm.
and then language idling on or near the premises outside of construction hours.
Yep.
All right, and if everyone's okay with that added language, we'll just revote on condition 8. All those in favor?
Aye.
Aye.
your next is number 10. Following our last meeting, Ken had raised the issue suggesting that the development be reduced to 7 duplexes, eliminating building number 5.
There was an issue with the retaining walls proximity to the lot line, I think it was.
Yes.
Yeah.
Excuse me,
Do
Mr.
we need
Chairman.
to include the? Let's see, it says, due to the retaining, it's included here.
All right, so
It's
the
included in the motion.
All right, so the proposed condition 10 says the development shall be limited to a maximum of 7 duplex dwellings, 12 total units with a maximum of,
14.
Say 14.
I'm sorry, 14, with a maximum of 42 bedrooms. Building number 5 shall be eliminated due to the retaining walls' proximity and impact on neighboring dwelling and property, and the inability to properly screen the impact. 4 of the units shall remain in perpetuity. Affordable to eligible purchasers whose annual income shall not exceed 80% of the area median income as determined by the U.S. Department of Housing and Urban Development. The 4 affordable dwellings shall be eligible for inclusion in the town subsidized housing inventory maintained by DHCD. Any increase in the number of bedrooms is a violation of the zoning bylaw and this comprehensive permit.
Mr. Chairman,
Yes.
excuse me. May I add some clarification to this?
You may.
I understand the reason why you want to take 2 market rate units away from us in Building 5 is because you're concerned about the impact of a retaining wall on abutting properties, the ability to properly grade. Is that correct?
That's correct, and that was, there was engineering comments regarding
All
that.
right, may I ask the board to allow me to give a visual to support or to clarify either one of 2 things? Please, let me finish. I know I'm not supposed to submit testimony. I'm not asked to submit testimony, either visuals for testimony that's already on the record to clarify and give you a better picture, or if you won't do that, can I ask that you open the public hearing, allow me to put a couple of pieces of information that I think will change your mind on that, and then close the public hearing.
I think we can certainly allow you to clarify a prior.
Okay, I have a visual here that I think will,
We have to, this is just a point of order thing. Wouldn't we have to reopen if we're?
I'm not submitting new testimony.
No,
on this.
I understand. I just want to make sure it's allowed. Or do we have to
I
open?
mean, you're in deliberations, so.
That's what I mean. Is it
so
allowed
other
in-
than a clarification, you're really not supposed to receive more testimony.
So this is clarification?
No, this is not testimony, this is giving you a picture of what it is that
Did
you're
you
doing
already
for
present this information?
This particular thing would just clarify information that's on the record and the comments that were made. It's not new testimony, it's just to clarify a picture for you. If I may just show you
I think it's dubious.
All right.
This is this is our Building 5, the one you want to take out. This is the property behind it, the Ariel Rubin's home. This is the retaining wall. It's 42 inches high.
Has this been presented? I don't think we can see
This has
stuff that
not
wasn't
been.
presented. I just don't think it's allowed.
Giving you,
it
it's
has not
clarifying
been
something that's already on the record.
But was that presented previously, this slide?
No.
Well, then we can't review it.
So I don't think we can consider that.
Then can you open the public hearing so I can submit it?
Not tonight.
Unless you think it's not gonna change your mind, because this shows that there is really no problem with that retaining wall or the grading behind that building that you're trying to take away from us to make this project
I'm
uneconomical.
basing this on what I presume, my amendment was based on what the engineering staff, professional engineering staff's comments on the plan were. And they didn't feel it was possible to do this without disturbing the adjoining property.
Is not what he said.
That's what I
Read
read
the
on the
comment,
note.
it's in the May 23rd letter.
Excuse me, this
This
is
isn't
not.
the place
this
for
is
that.
not-
Deliberation.
No.
I've said what I have to say.
No.
You do your thing. And thank you for letting me do this, and I understand your reluctance to it. I'm sorry.
Jen, I think you were gonna make a comment?
I'm not making any comment beyond that.
Okay.
I think we should
I mean, I
forward
would,
and vote it. I like the way it's
you
written.
know, I would think post-voting, if they would like to come back for an amendment or something, that could be something you can entertain, but you can't take new testimony now.
Right.
So through you, Mr. Chair, it'd be easier to do that than to try to post a new hearing and start all over again?
For sure.
So that's essentially what an amendment
That's what I
would
mean,
be.
Yeah, you'd have to re-mail out and everything else.
Right.
that would seem to be the shortest and most efficient. So we would either vote it down, he would submit additional information, and we would reconsider it.
You could.
We could.
You can also open the public hearing again, take in testimony and close it. That's allowed under the rules also.
Open the public hearing, is gonna be another notice sent out?
No, You can do it right now. This is a continued,
I
this is,
feel awfully
There's no
uncomfortable doing that with.
representatives
No
of the
rep- there's no one in the
neighborhood here,
public.
they
No
all
way.
know that this hearing is, the deliberations are continuing to tonight.
How is this posted?
No,
on the
deliberations.
agenda.
because-
Is deliberations, that means,
yeah.
yep.
Right, and the,
Highly irregular.
So let's
So
go
we
over
have-
item
We have the
10.
condition as drafted.
I think it's fine.
Which I already stated.
So vote.
All right, call it to a vote. All those in favor?
Aye.
Opposed?
Okay, your next change is number 14.
What's 11? Was that just a?
Oh, excuse me, that was an assertion of an example. We had the language about other structures, but there was a suggestion that we provide a sample so that there was more clarity.
Okay, so condition 11's clarified to include the example of any other structures such as sheds. All those in favor?
Aye.
Now 14?
Yep.
Not to complicate things, 13? It says on the property underlined, was that
Oh,
just a?
sorry, yep, that's a clarification also.
Okay, so 13's clarified to include 10 guest parking spaces provided on the property. So that's the language there. All those in favor?
Aye.
Aye. Now 14.
So again, we had the primary language here. There's a few clarifications involved here as well.
And the clarified language is the affordable units may not be rented or sublet, and that each affordable unit should be occupied by a qualified owner as their primary residence. And then on page 10, it continues. Any resale of an affordable unit shall be properly managed by an affordable housing specialist and reported to the ZBA and the town's affordable housing designee, and include the fact that any future owner is subject to all terms and conditions listed herein and as provided in the condominium documents.
Can I ask a question?
Sure.
What's the reason for changing principal to primary?
Oh, it was just a request. I mean,
Oh,
you know, I think if you have a preference for a different wording.
Came from it was a board request.
I
was-
like primary myself.
That's fine, I was just wondering if there was some, legal nuance that I didn't know about.
Actually, it is more legal than the other word.
Okay.
All right. So if everyone's okay with those changes, all those in favor?
Aye.
Okay, your next is number 17. That language is primarily provided through the engineering department.
So on 17, so that whole statement is just corrected?
Yes.
Okay.
And 17 reads, "A certified plot plan stamped by a licensed surveyor shall be provided to the ZBA for review and approval prior to the application for a building permit. The plan shall show, at a minimum, the following: lot dimensions, driveway limits of pavement, limits of sidewalk, building locations, building footprints matching the architectural plan dimensions, closest distance to nearest property line from each building, retaining wall locations, closest distance to nearest property line from each retaining wall, measured from the limits of excavation required for installation of the wall, including the wall foundation, wall extents, and any required drainage aggregate, reinforced backfill, and geosynthetic reinforcement. Locations of drainage structures, including limits of filtration areas and limits of work to be demarcated in the field. This plan shall serve as the base for an as-built plan of the project upon completion. And I think it says as-built pan. I'm
Yes,
sure
I need to
we'll put
add
the
an
L in
L
there.
there, yes,
Yep.
yeah.
All right, so if everyone's okay with that language, all those in favor?
Aye.
Aye.
Okay, your next, is a small change to 19.
Yep.
We're just swapping
What about
some
this,
wording.
in 18, you have underlined as
Prior
prior.
to certificate of
Of
occupancy,
occupancy.
yeah.
Okay, so 18 includes the language prior to certificate of occupancy. I think we already voted on this.
Yes.
What's a change? I think there was a change.
Right, it's just the minor change there. So if all those in favor?
Aye.
And 19 also comes with some modified language. A mailbox station shall be sited at the northwest area of the lot. All those in favor?
Aye.
Aye.
Number 20 is just a clarification to ensure that it's understood that trash removal and snow plowing will be private.
Okay. All those in favor?
Aye.
Aye.
21, we had the sidewalk listed along the northerly side. You know, it's a little bit of a clarification to say northeast.
Okay, all those in favor?
Aye.
22 again is language from the town engineer.
And that reads, due to concern about the installation of retaining walls, all wall components, drainage layer, pervious layer, geosynthetic grid, or other design features shall be set back a minimum of 5 feet from the property lines. The applicant shall be required to submit engineered drawings and designs to the board for approval prior to applying for a building permit. The design and drawings shall include cross-sections, profiles, details, and layout, including limits of work required on the site, showing that construction of the wall can be contained to the site without impacting the abutting properties.
Okay.
If everyone's okay with that language, all those in favor?
Aye.
Aye.
Item number 23 was again proposal by town engineering. There's always a concern for retaining walls above a certain height that someone accessing the top of the wall could potentially fall over a distance to the other side, depending on the height of the retaining wall. They have a recommendation to install a 6-foot tall fence on top of any retaining wall exceeding 4 feet in height.
Okay. If everyone's okay with that,
Yep.
all those in favor?
Aye.
Next is number 25. This is reflecting landscaping. It's also some additional discussion about management of trees. There's been quite a discussion, particularly with engineering, about the number of trees that are going to be lost on the property. Particularly a issue is those trees that are on or in proximate to the shared lot lines.
The added language states that trees to be protected and preserved shall be identified in the field and on a plan, a copy of which shall be submitted to the ZBA. Due to the extensive excavation and installation of retaining walls, additional landscaping shall be installed by the applicant along the southerly side of the retaining walls. If everyone's okay with that language?
Yes.
All those in favor?
Aye.
Aye.
I think the next one, actually 27, there's again some engineering comments about spot grading, et cetera, that they're interested in due to the lack of specificity related to potential retaining walls.
Okay, and that language states that construction shall be in accordance with all requirements of town engineering. including the town's 2019 soil erosion and sediment control standard conditions. All uncontaminated stormwater runoff shall be directed to recharge within the premises. No increase in stormwater runoff site is allowed. The applicant to submit a plan to the board for approval prior to applying for a building permit that shows spot grading along the property lines where the abutting property is lower than the site, to show that all stormwater will be maintained on-site as is required by section 240-112, Stormwater Management B design requirements, and 3, engineering sign-off is required prior to site disturbance and the issue of any building permit for this project.
I have one. There's no increase in stormwater runoff. I think that off should be from, no?
From the site?
Yeah, is allowed.
That's probably a little better.
I think that reads better, too. So everyone's okay with 27 with that change from
From the site.
the site is allowed? All those in favor?
Aye.
Aye.
Okay, next is 28.
Okay, it says dry wells shall be added to the plans, including installation plans for a 2-foot diameter, 2-foot deep dry well installed in a 2-foot envelope of crushed stone connected to roof leaders 15 feet off both rear corners of each house, or as alternatively approved by town engineering. Each homeowner shall be apprised of said installation to ensure maintenance and preservation of dry wells for the future, and this shall be added to the homeowners association documents.
So I just have a quick question on that. So, I don't know how the documents are, but usually the exteriors of the buildings and the structures are part of the association and not the individual homeowner.
Okay, yeah.
So the individual homeowner wouldn't be the one that's maintaining it, it would be the homeowners association?
Okay.
So how would you?
I don't know.
Yeah, how would we,
I mean, you
change
could
the
talk to the
language?
homeowner about the maintenance and preservation, but
Well,
the-
it just says they, the homeowners need to be made aware of it. Doesn't say they have to, they could go to the homeowners association
so why,
to get the money to fix it. But who's gonna notice? They're the ones that are gonna notice if they know it's there. Hey, there's flooding on the left corner of my lot.
so can we add a line that says the maintenance and preservation of the dry wells is the responsibility of the homeowners association?
Yeah.
It should say that, or it should be listed specifically as a common area or a common element.
What did you say? Maintenance
The
and?
the maintenance and preservation of the dry wells for the future will be the responsibility of the homeowners association.
The language as alternatively approved is just that if town engineering has a preferable design or some way that they can combine those, that may be amended.
Okay, okay with that language amended by Bob? All those in favor?
Aye.
Aye.
I think we're down to 37. We just have an addition there where it was requested that the applicants also include a copy of their condominium documents to be reviewed.
Is that a paragraph we already voted on, Maria?
I believe you did, but like I said, just the insertion of
Sure,
that.
we're just including condo docs to that.
So as to read how?
To include, on number 37,
Yeah.
Yes.
including and for condominium documents as a list of items the applicant's required to provide.
Oh,
37.
there's two 37s.
Oh, I'm sorry.
There's two 36s.
Yeah, once you go past that,
The second
I-
37.
Yeah, some of the numbering was off a little bit, and I will fix that for you.
Point of
So
clarification.
this 37 is the applicant is required to provide regulatory agreement and
So it's actually
declaration.
39.
so we can just, should we just, should we just
I'll
vote?
fix the numbers for you, yeah.
Do we need to vote to renumber them now, or just so?
Why not?
So let's start with the one that's 36, will now be 38.
So moved.
All in favor?
I think it's now 39, actually.
No, so we're at 34, 35, 36, 37, then it starts at 36, so that
Right,
next
so that
36 will be.
36 becomes 38, and
37 becomes
37
38.
becomes 39, yep.
38 becomes 40.
All right. We'll do a vote just
Just so we have.
just revising those paragraphs to reflect
We're going to have a lot of.
the numbers. All those in favor? So what is now 39? Adding the condominium documents to the list of documents the applicant's required to provide. Everyone okay with that?
Yep.
All those in favor?
Aye.
Okay, the now numbered 40, which is on the bottom of your page 13. The developer had mentioned that the homeowners were going to be paying condo fees 3 months in advance at purchase or move-in. And there was some concern expressed about the impact of those fees on an affordable homeowner. So this condition allows the affordable homeowners to only pay 1 month of condo fees at a time.
And everyone's okay with the
Yep.
new number 40? All those in favor?
Aye.
The rest are just renumbers. Then we'll be down to, on bottom of page 14, your number 44, which will now become 47. We just have added the language about unregistered vehicles being included in the condo docs, so that they're not allowed on the property.
And I think that reflects town by law as well, right?
Yep.
Okay, so everyone's okay with that?
Yep.
Yes.
All those in favor?
Aye.
Then that basically brings you down to the final vote. I guess I would also recommend, given that I will be making a few corrections based on your comments tonight, that you may want to vote based upon those corrections being included in the text.
Should we first vote for that, did alternates?
We vote for all of them.
So the Board of
What you
Appeals,
just said.
The corrections, yes. The corrections is.
So then I would make a motion that all the corrections that we discussed tonight and revisions be included in the final vote.
Second.
Okay, motion was made by Bob and second by Ed. All those in favor?
Aye.
Oh, I'm sorry.
I just wanted to note that on page 6, under 19, it has a list of things that the abutters had concerns about when they came and spoke during the public hearing. And I pretty much went through this, and I believe that we did a real good job of addressing those concerns and the conditions included in here.
Good point.
Thank you, Mary. And any further vote necessary, or?
I think that's it. I
Well,
think you are
So we have to
now
vote
down
now,
to-
though.
I don't think we voted.
Right, we voted to include the changes that we've made tonight.
Right.
Do we need any sort of final vote, or?
So, yes, so you just have a final vote for the inclusive decision. to grant or not the comprehensive permit as amended.
Right.
So I'd make a motion to vote to grant the comprehensive permit as amended this evening.
Second it.
Okay, motion was made by Bob and second by Ed. All those in favor?
Aye.
Opposed? Unanimous.
Future agenda items.
All right. Board updates, are there any?
So we had the last meeting for the zoning recodification group.
Yeah. I don't mean to laugh, but it is kind of funny.
Yeah, how'd that go?
And the initial hope was that it would be before this past fall town meeting. The next intent would be to have it before spring town meeting, but I guess that would mean that would have to be on the warrant in time for January. So I think the planning board is now looking at next fall town meeting for the recodification.
Okay,
Which makes more sense.
It has been an
Everybody-
extensive process.
yeah, sure was.
Bob and
That was an
Jerry
aggressive
have
timeline.
contributed to the efforts. We are all very much the wiser about every word within the bylaw.
And the current money for the Bobs that are reviewing it is out, so they need to renew.
That's my understanding, was that the town
consultants
negotiated
need to
a
redo.
very handsome deal.
Very good. Board discussion, is there anything? Future agenda items?
We did need that.
I have a question for Maureen. Has the,
Okay.
Tom Butt got back to us with a proposed date? He was going to try to get a speaker to talk to us on,
There was some conversation about a December date. I rather advocated on your behalf that you would potentially prefer to have fewer requirements made of you during December, and that perhaps it would be optimal to look into January when things slow down a little bit and you're looking for something to do, to have those.
Eloquently said, Noreen. Eloquently
I
said.
hope you said during the week, not the weekends.
To fill their winter nights.
Yes, so I have also requested that they give you sufficient lead time to be able to schedule that.
Always appreciated. Okay, our next hearing is December 5th, 6:30 here at Town Hall. Meeting adjourned.
Thank you, Noreen.